lords, kindly may move, make a mention for a posting of a matter, my lords. State appeal, my lord.
Yes. That's kind of serial number 49, contempt 49.
Yes, I appear for A1 and A2. Please, my lord, answer the complaint in this matter. It sought 3 consecutive adjournments in spite of repeated contempt, even after the finding of this contempt.
So what do you want?
I request for only Wednesday, my lord. We are trying to settle. My learned friend is well aware of
If
that.
trying to settle, then we'll grant time.
Wednesday, my lord. If it doesn't happen, we'll go on with that. May I ask for 20th, please, my lord?
20th.
My lord, you mentioned cause list number 12. Cause list number 12, I'm here to receive the interim relief orders. I'll come back to be heard when the number is called.
Pardon?
He wants to come back on the.
Your case is 12 all right.
12.
Yes,
My lord, serial number 59 will.
59.
I advise the client to withdraw the appeal because it becomes infructuous. To file a memo to that effect.
Respond, my lord. I filed a memo, having said it's become infectious. I've heard a copy.
59, writ appeal 132 of 2024. Learned advocates for the parties invite attention of the court to the memo already placed on the record, stating inter alia that the appeal has become infectious. In that view, request is made by learned advocate for the appellant, Mr. S.R. Ravi Prakash, to permit withdrawal of the appeal on the said ground. Appeal is permitted to be withdrawn and disposed of as infectious. All interlocutory applications will not survive any of the withdrawal of.
My lord, serial number
appeal.
52, my lord. 52, my lord.
52.
Yes, my lord. I'm for the accused persons. Complaints affidavit ready, my lord. I have filed it in the registry. Complaints affidavit is ready, my lord. I have filed in the registry, my lord.
What is the mention?
My lord, it may be taken up for next week, my lord.
Next 22nd.
Any day, my lord.
22nd.
Please, man.
Let's
Inform the other side.
I am for the complaint, my lord. Inform.
State appeal, my lords, where a land belonging to the government, where a school is situated, my lords, by virtue of an order passed by the learned single judge, the respondents, in spite of an appeal being filed, notice being issued by my lords, and the date given is on 12/9, they are now clearing up the property to build up an structure, my lords. I would only request my lords to hear us for an interim order, my lords. Land belonging to the government, what has happened is, from 1957, we are holding on to the land, my lords. By virtue of a grant order, now they say that the
You remove the office action, it will list.
well, matter was listed, my lords were granted to, pleased to grant a notice. 12th of September is the date given. But in the meanwhile, they're,
File IA.
I will do it. IA is also filed, my lords.
So then move IA, remember.
Please, my lords, I will do that. Oblige.
My lord, this petition is related
Yes,
to.
madam.
May I make a submission? This is the fresh writ appeal matter, your lordship, wherein there is an order from this honorable court to evict the petitioner and her family, your lordship. The date of order is 12/6, your lordship. Within 30 days, the petitioner and her children has to vacate the property, your lordship. Hence, there's urgency to hear on stay.
It is already over. 30 days are over since long back.
No, your lordship, it will be on 12th of this month, your lordship.
12th of this.
Yes, your lordship.
When the order was passed.
12th July, your lordship.
12th
Yes, your lordship. The
12th.
petitioner is daughter-in-law
On
and
12th.
children.
to be posted on 12th.
On 12th. Grateful, your lordship.
My lord, this is the petition relating to medical admission on PWD quota. So the same matter is posted on 13th. And the same matter connected with matter is posted on 13th, my lord. Next-
13th.
Yes, ma'am.
13th.
Connected.
My lord, serial number 8, my lord, for the respondent. Respondent number 3 also filed an writ appeal, my lord. It can be connected, tag with this. Above.
For the appellant, my lords, they have also filed another writ appeal emanating from the same order. may be tagged together, my lord.
Yes.
The matters may be
When
taken
it
up
is-
together for consideration.
When it is called out, we'll take
Yes.
Please.
My lords, serial number 33, my lords.
30.
I seek some time, my lords, in that matter, my lords.
Pardon?
I seek some time in that matter, my lords.
33. When do you want? 3rd of September?
Obliged, my lords.
At the request of learned advocate for the petitioner, extend over to 3rd September.
Obliged, my lords.
My lord, serial number, may I make one submission, my lord?
Yes.
Serial number 18, my lord. In the contempt petition, the state, my lord, has filed the affidavit, my lord, and unconditional apology. Regarding that, my lord, may kindly drop this contempt proceedings.
So you are for
Complainant,
complainant. So what do you want?
and the state, my lord, in view of the affidavit filed by the state, my lord, unconditional apology. The recording that, my lord, may kindly be, the contempt proceedings may kindly be dropped, my lord.
So you are withdrawing.
Lord, your lordship may kindly say, my lord, the accepting the
Then-
affidavit.
Then let it be called out. Not
Please,
now.
please, please.
Educate. Student.
The list two, seal number one, Aditya D.
Yeah, for the petition. My lord, the writ petition has become infructuous, my lord. The respondents have considered my representation and they have
Learned
given-
advocate Mr. So-and-so stated that the respondents have considered the representation of the petitioner. In that view, the petition has become infructuous. Memo of paragraph, memo of withdrawal dated 6/8/24 is tendered on record, is tendered, which is taken on record. Any of the statement, the petition stands disposed of, requiring no further adjudication.
Seal number two, Mr. L. M. Chidanand.
Petition. That the petitioner was granted the permission to start MDS course in the year 2000, academic year 13 and 14. But for the academic year up to 18, there was a permission. But this permission was revived by the central government on 21st of July 2023. I have been requesting them to make admissions in 7 specialities of MDS course. They have not included in the seat matrix and not made admissions. There are about 20 students who will be affected every year. Annexure Q is the permission granted by the central government.
Page,
Page 76,
then,
21st of July 2023. I am directed to refer to your letter dated on the subject mentioned above. It has been requested grant permission to take
page?
admission. BDS and
Which?
MDS,
which page?
page 76. 76.
So what was the original seat matrix for 23-24?
Initially, totally it was 7 specialities. I have produced the documents.
How much?
7 specialities.
7 specialists.
Specialities. The central government also makes clear that there is no change in the seat matrix. The total sanction strength of MDS is 20 seats.
26.
20 seats totally for all 7 specialty. 3 one subject is only 2. So there are about 20 seats. Now, by virtue of the order of the Supreme Court, on section 10D, I cannot make any admissions directly on my own. Now it is the state government which will include in the seat matrix. Then the Karnataka Education Authority will admit the students. 20% will be given as free seats. 80% insofar as a minority education is concerned, they will be treated as the payment seat fixed by the state government. I have given letters after the orders of the central government, 2 letters to the 6th respondent requesting to include in the seat matrix and consequently admit the students in the study of MDS course. The 6th respondent has not taken any action. Consequently, my lord, fifth respondent has not made any admissions for these MDS courses. Therefore, I am before your lordships. My lord. The first letter I gave is, my lord, Annexure T, page 84. My lord. The annexure you also, my lord, very recently I gave another letter.
Why you are not included?
Please,
Why you are not included in the seat matrix?
my lord, no reasons are given, my lord, because once the central government grants, my lord, in 2000, my admission was there up to 2018, my lord. 2018, the university did not renew the affiliation. My lord, subsequently, we requested them, my lord, they re-inspected and renewed the affiliation. My lord, on the letter of the Rajiv Gandhi University, my lord, the permission was not granted by the central government for the academic year 18, 19, 20, 21, 22, 23. My lord.
All they were recognized?
Please, my lord.
All admissions were approved?
No, all admissions up to 18 are approved, my lord. But after 18,
So-
no admissions are made, my lord.
Seat matrix is approved every year, every academic.
Every year it will be approved. The university, my lord, carries out inspection, grants affiliation every year. Whereas the central government grants affiliation, my lord, till the course is completed. Once it includes into the college under section 10(2), my lord, then it is a responsibility, regular inspection will be made.
So paragraph 31,
Yes,
governments refers to page 76.
please,
So that respondent 4 and 5 failed to notice that
please.
respondent is granted permission on 21/7/23.
Yes.
Same, 21/7.
Yes.
So last year you admitted,
No, we have not admitted, my lord.
not admitted.
Because I cannot admit, my lord. It is
What is the effect of this page 76?
please 76, my lord.
He says that
Yes. The 76 is, my lord, the permission which was stopped, my lord, in between. For the academic year, my lord, the university did not renew the affiliation. Central government prohibited me to make admission from the year 2018 and onwards, my lord. Then the permission was revived.
So that is what we are asking. Since 18, there is no approval.
No admissions, my lord. No admissions are also.
Because you have continued to admit the student.
No, my lord, no admissions are made. I cannot make any admissions, my lord.
So then
It is
what
only the fifth respondent has to make admission.
So why after this gap you are seeking?
My lord, the permission was only granted in 2023. My lord. Central government re-granted the permission to admit the students.
Re-granted.
Yes,
From
2018 to 2023, we did not have permission, my lord. And it was re-granted, my lord, on 21st of July 2023
re-granted for which year?
for the academic year 23-24, my lord.
So what happened between the interregnum?
Those admissions no admissions are made for those years, my lord.
So those who might have continued the studies, what happened to those students?
But those studies will continue, my lord. Those who are admitted up to 2018, their admissions are recognized because the notification issued under 10(2), my lord. Annexure J1, my lord, kindly see, my lord. Just may I clarify, my lord, it's your lordship permission. Now the admissions will be made. Admissions will have to be made only by the fifth respondent. The petitioner cannot make any admission on its own. Only when they send the students, then we have to admit them.
Or learned advocate, Mr. So and so, notice returnable on.
Tomorrow is the last date for admission. This year, well, at 24 and 25, 20 students, because 20 seats will go to free students. Well. Right, of course, there is a delay on the part of the petitioner, but the fact of the matter is,
You are not only that the interim cannot be granted, you are concealing something from the court. You are suppressing something from the court.
well, no,
Previously notice.
may I just submit? Well,
There is no question of grant of an interim. If you can say we are ready to give reasons for refusal.
no, Millard, I am not asking that, Millard, but I have not suppressed anything, Millard. I have placed before our
On
lordships,
the, on
Millard.
the next date, we will tell you. Returnable on 23rd of August.
23rd of August. Millard, may I take notice to the AST, Millard, all our state authorities? Millard?
Yes.
Yes, notice to the respondent one, Millard, I think. The standing councils, Millard, if I am permitted to take, Millard, it will.
In addition to normal mode of service, will be open for learned counsel for the petitioner to serve risk number one through the counsel who normally appears
Standing council.
on behalf of number one.
Yes.
In addition.
This is number 3, Surat Sampath.
For the petitioner, my lords.
Millards for the respondent number 2, Millards.
This is the matter wherein I had written the AIA PGET exam, my lords. They removed me midway through the course after 10 months, saying that my marks are below the requirement in NEET exam, my lords. Annexure D is that notification. By my lords, interim order, I've been attending classes.
Permitted to attend the classes.
Yes, my lords, I've been attending
Also
classes.
appeared in the internal essence exam.
Yes, my lords.
So today,
Millards.
there is no urgency. There is no urgency.
There's no urgency. They've not filed objections, my lord,
We'll put up on.
but it may be a matter that can also be disposed of, my lords.
In view of order dated 25/6/24, the petitioner is permitted to attend the classes and is also permitted to appear in the internal assessment examination, full stop. The examination has already taken place, full stop. The petition awaits the filing of the counter affidavit by the respondents, which shall be filed within 3 weeks. Stand over to 15th of 17th of September.
Please, much up.
List 1. List 1, number 1.
My lord,
Content matter, Mr. Y. Aripta.
the petitioner complainant here in my lord is the tenant under the complainant here under my lord, the tenant under the accused 2 to 5, my lord. He is the tenant from the effect 2012, my lord. And he is running the PG there, PG, and 2019, the owners 2 to 5 obtained the loan from the bank. These are not handed over, my lord.
List number 2. Srimati Tejaswini.
Complaints, Your Honor. As per annexure F, page number 84, interior matter granted by this honorable court in RSA 2030 of 2018, Your Honor. Annexure F, page number 84, Your Honor. Last para. By violating the interim order passed by this honorable court, respondent number 1 and 2 are constructing the some development activities on the social property, Your Honor. Hence, this complaint filed by this honorable court, Your Honor. As per Annexure F, page number 84, this honorable court has granted interim order status quo maintained by both the parties, Your Honor. By violating the disorder, respondent number 1 and 2 are doing the development activities on the social property as per the photographs shown in the Annexure G1 to 8, Your Honor. A part of that Your Honor contempt before this honorable court is.
Number 3, Puttegoda.
The complainant herein is approaching this honorable court, aggrieved by the order of the respondent herein failing to implement the order of this honorable court in writ petition number 56820 of 2018, my lords, which is marked as annexure. Please.
The PL matter, number 4, Mr. Srikanth P.
If I may please your lordships. Lordships, fortunately or unfortunately, I'm standing before you for the second time in the past five weeks on a PIL issue. The respondent 1 issued a notification on 11th of July, where they notified a bill, which is referred to as the Karnataka State Employment of Local Candidates in Establishment, Industries, Factories and Other Establishment Bill 2024. This was issued, the notification was issued on 11th of July. On 16th of July, there was a newspaper report which carried news that the cabinet has approved this particular bill. And this PIL petition came to be filed on 19th of July. Lordships were pleased to list it on this particular day. There are two contentions, my lord. Number 1 contention is it looks and feels similar to the Haryana State Employment of Local Candidates Act, which was issued by the government of Haryana and struck down by the court of Punjab and Haryana. So the issue was already considered by a coordinate court or a corresponding court, and the court has already issued already passed order on merits, which is something that can be seen in page number 79, my lord. Page number 79, para number 32. Which says the perusal of the above would go on to show that there is a specific bar to the legislature of the state not to make any laws in respect of any manner which are under Article 16(3). The same further provides there should be equality of opportunity in public employment. Now, this is a reservation which is pertaining to private organizations. Page 79, there is a judgment of the Punjab and Haryana High Court, Annexure B, my lords. There's an observation by the Punjab and Haryana High Court. Choose, may I continue? May I continue? 75% reservation in management category and 50% reservation in non-management category. And moreover, it is going against the intent of the benefit of the local candidates, because a local candidate who is defined under section 2H in page 38.
To here 2020. In other words, comma, it was a legislative enactment which was challenged before the Punjab and Haryana High Court, comma, as stated above, present challenge is to the bill. It has not assumed the character of law. The petition is thoroughly premature. Paragraph. On the aforesaid ground, on the aforesaid ground alone, comma, without going into the merits of the contentions of the petitioner and without expressing any merits on the aspect, comma, the petition is dismissed.
My lord, may I bring to my lord's notice, my lord? Page
It can part
26
so
may
and so, so
be
and so.
seen, my lord. My lord, page 26. My lord, paragraph 2 and paragraph 3. It's not a public interest litigation as is being made out, my lord.
Page,
Page 26, particulars of the petitioner. My lord, the third sentence. My lord gets it. The petitioner is also the regional mentor of change. My lord gets it. Page 26, paragraph 2. Third sentence.
Lords, how does that have a,
My lord, my lord, then the undertaking given by the petitioner may be seen.
who heard learned advocate, this one,
Lordship,
and learned, 1 second, and learned additional government advocate, Ms. Srimati Nilofar Akbar, for the respondent state. Upon service of copy of the petition in advance.
Lordship, it's a pro bono assignment. It does not have any public status as such. And it is for
Outset. Which may look learned additional government advocate invited attention of the court to the averments in paragraph 2 of the petition to submit that the petitioner is a chartered accountant and doctorate in chartered accountant who is a regional manager regional mentor of change with Niti Aayog. And that due to the, and that on account of the bill sought to be challenged in the present writ petition, her chances for resuming employment would be hindered.
Yes.
She is not employed, my lord.
Therefore submitted that there is a definite element of personal interest
Yes.
in the petition.
Lordship,
She admits and
This contention could not be brushed aside lightly, full stop. Then even
Lordship.
otherwise. correct.
Lordship, it is a pro bono assignment. It has got no interest in the litigation as such, Lordship, it may be, she is a pregnant mother, my lord.
Whatever.
My lords,
hardly
it is,
matters to
she is not representing the union at all.
Petition is dismissed with the cost of rupees 5,000 to be paid to the.
Lordship, the
Karnataka High
cost,
Court Legal Service.
Lordship, the cost is,
After seeing this element, we are not. Yes.
Lordship, it may be she's already undergoing a pregnancy, my lord. This is too much of a cost for her, my lords, and it is kindly, my lords, kindly, my lords. She's a pregnant mother, my lord.
So what?
No, my lord. There is no malafide, my lord. There is absolutely no
No
malafide.
sentimental arguments in court of law.
There is no malafide, my lord.
She is
She's
concerned with only law.
and
nothing
she is not the regional mentor of change anymore.
Take out the cost part. Yes.
Immensely obliged, my lord.
Green bench matters, seal number 5. Ravindra Gajanan.
Please, my lords.
Yes.
The petitioner, a private patta landholder, my lords, applied for the grant of a quarry lease within his private patta land, for which he has already obtained revenue NOC, forest NOC, and technical report. Later on, letter of intent was also issued. It is produced at Annexure E at page 45 and typed version 51. And recommendation was made by the District Task Force Committee to grant the portion of quarry lease area as required under Rule 32(6), my lords, of KMMC rules. And the 3 or 4 conditions were set out in the letter of intent that the patta land should be converted into non-agricultural one. Number 2, quarry plan approved, approved plan is to be prepared. And third, the environment clearance certificate is to be obtained. All those things were obtained, my lords.
Please you notice. Notice returnable on.
Please, my lords.
18th September.
Writ appeal matters,
You will be accepting for task.
number 6, the appeal by government.
my lord, I appear for, my lord, the appellant. My lord, this is a state appeal that has been filed, my lord, being aggrieved by the order of the learned single judge. My lord, here the respondent number 1 seeks for grant of salary grant. My lord, from the date of appointment to the date, my lord, his post was admitted to grant. My lord, similar matters are pending. My lord, before this honorable court in WA 2475 of 2015, my lord.
There is a delay, will you note?
Lord, I appeal for the only contesting respondent. The
The only contest.
please,
Lord, the risk,
What is the delay?
Lord, the. very
191 days.
Please, Lord, a very government here filed a writ appeal under the misconception that this matter pertains to challenging the constitutional validity of the Karnataka State Private Aided Educational Institution Employees 2014, and petitioner is seeking for pay fixation, increment, leave, seniority from the date of grant. That is not the writ petition filed by the writ petition before the my lord writ court. Complete writ appeal is pertaining to some other matter has been my lord sought to be my lord challenged before this court. My lord, matter pertains to my lord the petitioner before this court is. My lord, the petitioner was appointed on 27/5/1989 as a second division assistant and my lord accountant. My lord, thereafter on 28/12/1989, his appointment was approved. My lord, during that period, there was a my lord, ban on my lord, economy major by the state government. My lord, the state government, my lord, wide annexure C, my lord, page 84 took a policy decision to admit the my lord, non-teaching staff of around 1,116 for grant in need. May I request me kindly peruse my lord, the order, government order dated 9/6/1999. It is not the matter pertains to as my lord submitted by the
My
government.
lord, one of the issues.
No,
in
no,
that
no,
writ
no, my lord.
appeal
Absolutely, there is
pertains
no,
to-
absolutely, there is no connection whatsoever. Now, my lordship may kindly see this page number 84. Left 83, government order dated, my lord, 9/6/1999. May I read, notes? The government has given the approval for providing of the grant in need under staffing pattern properties of the private aided high school and private aided university college for those non-teaching staff who are appointed prior to 1/1/1990 and during the time of
IA number 1 of 2024. Heard learned additional government advocate Srimati Neelofer Akbar for the applicant state and learned advocate so-and-so person to the respondent, who appears for the respondent. The present application is filed seeking to condone the delay of 191 days, which has taken place in filing the writ appeal. In the accompanying paragraph, in the accompanying affidavit, the applicant state has spelled out the reasons leading to passage of time. It is stated that after the judgment and order of learned single judge on 12/6, passed on 12/6/23, the office of the Advocate General applied for certified copy. Thereafter, the legal opinion of the government advocate was sought for. Full stop. By letter dated 1/8/23. Proposal was forwarded to the Commissioner of Public Inspections, who in turn forwarded the papers for necessary action to the government.
the commissioner sought for
Defense Department,
WP number is wrong, my lord. 4491 of 23 commissioner has sought. The year is not the request.
Finance Department and other departments considered the matter. Finally, it was decided to prefer the appeal before the court. The legal cell processed the case further and handed over the papers to the office of the Advocate General. It was submitted paragraph that the aforesaid procedure resulted into delay of 191 days. Most of the reasons supplied are of administrative in nature. Full stop. The time is consumed in the decision-making process before it was finally decided to prefer the appeal. The applicant is a state government where the decision-making process inherently takes time. Sufficient cause paragraph is made out. Delay is to be condoned. It is condoned. Application is allowed. So appeal will be considering on some other day.
May I request for posting the matter for admission?
Lord, contempt is also filed. It's connected along with
It's
the
tagged
appeal.
along with, it is already tagged.
Yes, yes.
So you are a school.
My lord, please, my lord, I am school, my lord, my appointment was admitted in the year 2004. My lord, I requested the government to, my lord, to accord the admission, my lord, a grant from 1999. Writ petition filed before this court by 3 writ petitioners. In respect of other 2 writ petitioners, my lord, immediately it was complied. Only in respect of petitioner, my lord, benefits have been denied. So, my lord, your lordship may kindly see the writ petition order passed on 9/7/2008. Lord, 3 writ petitioners approached the High Court, page number 100. Notes. Page number 100. Notes. The writ petition allowed matter was remanded back to the, my lord, government to reconsider. Immediately without wasting time in respect of petition number 1 and 2, my lord, government complied it and, my lord, given the benefits of arrears with effect from 9/6/1999. Only in respect of petitioner, my lord, benefits have been denied. My lord, I filed an appeal under 131. I succeeded in the appeal, my lord. My lord, government filed a review petition before the, my lord, government, the respondents commission filed a review petition government. Government allowed the, my lord, allowed the review petition. Now, Leonard Singhal says,
My lord, I understand. My lord may grant me
there is no
some
merit
time.
in the case.
My lord, I understand, but I didn't want to make, my lord, anything. My lord may grant me some time. That is the difficulty that is there in that appeal.
You go to page 100, read the judgment, whether this judgment must be final.
No, I understand. Like to have a discussion with the department and then make my submission.
Now, my lord, my only submission is, your lordship may kindly see the content from writ appeal para number 3 to, my lord, end of the para. Under the wrong impression that the petitioner has challenged the constitutionality of these rules has been filed.
Very fairly stating why or will take
No,
up-
therefore, my lord, there is.
Let him have the time to at least contemplate taking.
Start date. I only request because I am litigating from the last, my lord, 25 years from
21st August.
20th or 22nd.
20th.
Or 22nd.
My lord may
It's
have this
22nd August.
Please, much. Both, my lord, contempt may allow me.
Number 7. Vivekulla.
Appellant's counsel. 1961, my lord, there was an acquisition under the Land Acquisition Act of 1894. My lords may come to, my lord, the notification is at page 42. English version, my lord, type copy, my lord, is at page 45. This, my lord, acquisition did not go through. After, my lord, 30 years, the land, I'm sorry, 79, my lord, the land was granted in favor of, my lord, the vendor of our person, my lord, appellant. Page 59, my lords, get that, my lord. There was, my lord, grant, page 59. Typed copy, my lords, get that at, my lord, page 62. Sorry.
After 53 years.
My lord, what happened is, can I put it this way, my lord? 1961, there was an acquisition. Under the Mysore, my lord, under the Land Acquisition Act of 1894. (1979), that is, my lord, after a lapse, my lord, they did not complete the transaction, acquisition. Therefore, 1979, the Special Deputy Commissioner, my lord, grants the land in favor of our vendor. Page, my lord, 59, my lords, get that. My lord, I have prepared a short list of dates. 79, my lord, that is, after a lapse of, my lord, 18 years, there was a grant. So, my lord, the acquisition was not completed. Say, my lord, I have put it in a short synopsis. 79, my lord, this property was granted by the Special Deputy Commissioner. It was thereafter, my lord, sold after 30 years to me. Khata stands in my name, my lord, in the BBMP records, Bharat Bangalore Mahanagar. We have paid the taxes. I go before the BDM, my lord, for plan sanction. They say, no, there is one, this thing, old notification. So we can't give it. Therefore, my lord, I had no choice but to challenge it. Though strictly, my lord, it is not needed. Learned single judge, my lord, does not consider any of these. Holds that, my lord, BDA, my lord, the section 24 to the new act does not apply. This is under the old act, my lord. Land Acquisition Act 1894. And none of these documents, my lord, have been considered by the learned single judge. Para 13, my lord, learned says that it is under the BDA Act. It is not. The notification itself shows it is 1894, my lord, Land Acquisition Act. The limits are there.
So all along you are in possession?
From since the beginning, my lord. 79, grant, my lord, in favor of my predecessor. 79 to my lord, till date. BDA note sheet also says, my lord, that there's no development by them. And we are in possession. That's what their note sheet is at page 185.
And what is section 27 of BDA?
27, my lord, lapsing. If, my lord, the property is not, my lord, utilized by the BDA for 5 years, the acquisition lapses.
This was acquisition by BDA or for BDA?
CITB, my lord, under the Land Acquisition Act, my lord, not even under the CITB Act or the BDA Act, my lord. So, my lord, all that strictly does not apply. There is an abandonment. In fact, this on...
You're relying on section 24 of the 2013 Act or this 27 of the BDA?
That plus, my lord, plus. There are judgments of this honorable court where your lordships have held, division bench judgments as well, that, my lord, if the acquisition is abandoned, then, my lord, they can't say that, my lord, I have no right to, my lord, challenge it.
But here is abandoned.
Yes, my lord. They have not, my lord, taken possession. They have not passed award. They have not done anything.
Final notification is it?
Only final notification, nothing else. That I have placed before your lordships.
Final notification will amount to vesting of the...
No, my lord. That is under section 17. For, my lord, there has to be a 16 notification. Then, my lord, there has to be a actual physical possession being taken after the award. Can I, my lord, pass on some judgment for my lord's consideration?
What about delay?
My lord, if for 15, 25 years, my lord, I have no choice because when I went to the BDA for plan sanction, they say, no, there is this. So, my lord, I have no choice but to, my lord, challenge it. Otherwise, my lord, my submission is I could have kept quiet. I went to the BDA, my lord, because planning authority is them. So, when I went there, they said, you'll have to, this is there. In fact, my lord, their note sheet says that I'm in possession. Please come to, my lord, page 185.
But you are the subsequent purchaser. How the land came to be granted to you?
My lord, the acquisition was abandoned. If the acquisition is abandoned, my lord, can I pass on some judgment for my lord's consideration? Can I pass on, my lord, some judgments of this honorable court where abandonment, my lord, occurs? In fact, my lord, the government granted me the land. It's not, government sought acquisition. In fact, my lord, if your lordships look at, my lord, page 45, acquisition is by the government. And, my lord, they abandoned it. Thereafter, my lord, they granted it.
So then delay stares at your face.
No, my lord, my submission to your lordship says, I went before the BDA, my lord, sanction plan. My lord, please look at it. Khata is in my name. Tax paid receipts. Everything is in my name. Government grants it to me, my lord, in 1979. Can I, my lord, pass on some judgment for my lord's consideration, lord? The Honorable Supreme Court and this honorable court have held, my lord, if there is an abandonment after 15 years, my lord.
So with heavy heart notice.
In fact, my lord, I was telling the council, you shouldn't have come before the court at all, my lord. We had the kata,
That's correct.
that should have been.
That's
This
right.
is like, my lord, there's a saying in Kannada, like, my lord, taking a stone and putting it on your own head.
September 19.
Please.
Third learned advocate, learned senior advocate, Mr. Uday Holla, notice written on us. No, just a recording your name.
No, even then, what I should have been here. Sorry.
Yes, next.
This is number 8.
Please, my lord.
Please, Arjun Poya.
My lord, for the appellant. Respondent,
Pardon?
third respondent, my lord, filing memo stating that third respondent also filed an appeal in 429/24. Kindly tag with that same judgment we have.
Maybe tagged,
Yes, ma'am.
to be tagged.
Yes, ma'am.
It was stated that the writ appeal number
429, my lord.
429 of 2024.
Yes, ma'am.
Arises from the same judgment and order.
Yes, ma'am.
Which is under challenge in the present appeal. Therefore, the present one and the said writ appeal numbers also shall be listed together on
Any day.
20th September,
Yes, great.
on 23rd September.
Much, great.
Number 9. The appeal by state.
Lord, I appear for the appellant, my lord. In this appeal, there is a delay of 228 days. My lord, there is an observation made by the learned single judge for which I'd like to seek instructions, my lord, page 33 of the order of the learned single judge.
There is nothing.
My lord, page 33, 7th line may be seen, my lord, order of the learned single judge. My lord, could I just,
Set apart,
yes, could I just seek instructions with regard to that, my lord?
notice returnable in CA, in IA as well as in the main appeal. Returnable on 21st August.
Obliged,
Today is not 21st, it's too early. 28th August.
obliged.
Number 10. The Sachin BS.
Respondents 1 to 30.
My lords has already granted interim order in a connected writ appeal, the detailed order maintaining status quo.
Blood in this petition, blood. The petitioner's service for withdrawn, my lord. And in fact, they are without salary since September 2023, my lords. And in fact, that order is not applicable to this at all, my lord, because their service have been regularized.
All writ
Service have
appeal
been withdrawn. And their say has been reverted back to daily wages.
That is writ petition number 10632 of 2021. That was a subject matter writ appeal, my lords. This was connected along with this presented petition. My lords, page 26. My lords, the connected writ appeal, my lords, that is in respect of WP number 10632 of
Arising out of same order.
same order.
Blood in this writ appeal, my lords. The petitions service, they were regularized, their services have been regularized. And since in 2018, there are some of the petitions are retired also, my lords, and their services have been withdrawn. Whereas in the other case, my lord, their services were not regularized.
The
So
interim orders,
this order will go on.
that is also applicable, my lords, because their interest also is protected by my lords.
The challenge in this writ appeal is directed against common judgment and order dated 7th March 24 passed by learned single judge in 4 writ petitions, which were writ petition number 10632 of 21, writ petition number 4553 of 2022, writ petition number 27469 of 23, and writ petition number 27478 of 2023. Full stop. It is a matter of record that against the very judgment and order relatable to writ petition number 10632 of 2020, insofar as it related to writ petition number 10632 of 2021, the university referred writ appeal number 705 of 2024, which resulted into order dated 9/7/24. Said appeal is pending. The present appeal is against the same judgment and order. However, relatable to same common judgment and order. However, relatable to writ petition number 27. However, it is relatable to writ petition number 27478 of 2023. In view of above, the present appeal shall be heard with writ appeal number 705/2024, order passed in writ appeal number 705/2024, more particularly, directions contained in paragraph 5 of the order shall govern the rights and obligations of the parties in the present case also.
One submission, my lord. Let's kindly, direction may be given to the university because they are without salary since 1 year, my lord. The employees all, because they are D group employees, they have no salary and no service also, my lord. 1 year without salary, they are something.
So what do you want?
Sir, directions may be given to the university to release.
Order, same judgment. We can't improve upon it this stage.
Publish.
Yes.
Delay be condoned, sir. Delay of 7 days be condoned.
Delay, any other party is there?
No, all are, sir. Territories.
So heard learned advocate before that order in I heard. This is heard learned advocate Mr. So and so for the applicant university, learned advocate, learned additional government advocate Ms. Srimati Neelofer Akbar for respondent state, and learned advocate Mr. So and so for the private respondents. In this application, delay of how many days?
7 days.
Is paid to be condoned, full stop. From the averments made in the accompanying affidavit, the delay of 7 days is explained with sufficient cause, therefore it deserves to be condoned. It is condoned, application is allowed.
Okay.
An order in main appeal.
Number 11. The MS Devraj.
For the But respondent sought to execute a sale deed. That, my lord, was refused by the registrar. He is my GPA holder. This honorable court, my lord, directed, my lord, that that particular sale deed be registered. My lord, page 212, if your lordship turn to, my lord, 212. At, my lord, 219. The registration, my lord, was refused. Ultimately, my lord, this honorable court at page 249 directed, my lord, that particular sale deed be registered. Instead of registering that sale deed, my lord, as directed by your lordship, my lord, he goes and registers some other sale deed. Therefore, we are before your lordship.
The sale deed is between you and?
My lord, sale deed is, my lord, my lords get that particular, sorry.
How can you file a writ petition to set aside the sale?
Not me, my lord. What has happened is, this honorable court, my lord, directed a sale deed to be registered, my lord, in terms of annexure D. Please, I did not file it. He first came before your lordships. Please come to page 249.
240?
My lord, 212. That's the order of this honorable court rendered by his lordship Justice Arvind Kumar as he then was. 212. Please come to 249. Serial number 4. Bottom, my lord, your lordships get. Fourth respondent is directed to register the absolute sale deed dated 5/2/2018, annexure D, presented by the petitioner forthwith by collecting registration fee. What he does is, he registers some other sale deed, my lord, in furtherance of this direction of your lordships. He is my power of attorney holder. He, my lord, sells, my lord, my own land. Second, my lord, first sale deed, my lords get that at 199. My lords may look at the schedule, my lord. What is being sold is a specified area at page 204. The present sale deed, my lord, which he goes and executes, is at page 251, a different schedule at 257 and 259. This is all, my lord. Pursuant to your lordship's directions, he goes and does this. My problem, I can air it before your lordships. He goes and files a civil suit. Now, my lord, in the civil suit, he takes up the contention that, this registration is pursuant to the directions of your lordships. That's my difficulty. At page 267, my lord, his contention is the sale deed, my lord, which is now executed by him and registered, is in terms of the direction of your lordships. So I had to come before your lordships.
The sale deed is between whom?
Between me and my lord, my power of attorney holder executes a sale deed. He, my lord, sells my lord, some other sale deed. My problem is I had entered into a joint development agreement. He was to, my lord, get some portion. I have to get some portion. He goes and, my lord, registers a different sale deed and says, I have registered it pursuant to the orders of your lordships. That's my difficulty, my lord. I had to come before your lordships.
And the order you are showing at page 249 is only requires the respondent to register the sale deed.
Yes, my lord, annexure D.
Nothing more. Nothing
Correct, my
turns
lord.
upon
He
you.
registers some other sale deed and goes before the civil court saying that, my lord, pursuant to the orders of this honorable court, he has registered that. I'll have a difficulty in the civil suit. Please look at it. If your lordships directed that sale deed, then, my lord, in the civil suit, I have no defense at all. Please come to, my lord, page 267. His own statement at paragraph 14 of the plaint. 267, paragraph 14. 1-4. During this period, as the Honorable High Court of Karnataka had in WP number 10582, that's, my lord, Justice Arvind Kumar's order, directed the sub-registrar to register the sale deed to the plaintiff. As per the directions of this court, sale deed transferring 57% is registered. My share, my lord, he goes and registers. I had given a lease deed in favor of the third party. This is my problem. Civil court will not, my lord, civil court will say, look, High Court has directed, therefore I am bound by it.
Same sharing of the any further observation veracity from the pending. So suit is also pending.
Suit is pending, my lord, but my problem is, my lord, please look at it. In the suit, he takes the stand. High Court has directed this registration, and therefore, my lord, and the trial court, my lord, can't do anything. Please look at it, my lord. This honorable court specifically directed annexure D be registered. He goes and registers, my lord, something else and says, in terms of the order of this honorable court, I have registered it. Now, my lord, where do I go except come back to your lordships?
That we can clarify that independent of that direction, suit will proceed.
I'm in your lordship's hands, my lord.
Dismissed with that clarification. In fact, learner single judge dealt with that aspect
Strictly no, my lord.
in some way, in some.
It is, my lord, that has to be clarified. Otherwise, my lord, what will happen is.
Page 48.
Yes, my lord.
It's up
Please
in
look
the
at it,
middle.
my lord. That is, my lord, he refers to, my lord, the order of this thing.
Submission on learners in
With appeal number. In the earlier, my lord, I had also cited another judgment.
So we'll say that.
Very well, my lord. I'm in your lordship's hands. Because I don't want, my lord, tomorrow, the civil court to say that registration is because of this. Grateful, my lord. Please. Great. Probably it has to be disposed of because dismissed in the sense they'll say, oh, it is already dismissed.
We say we are not interfering with the judgment.
No, only thing is my lord, that observation, because I'll tell you a lot.
Subject to observation.
That's it. Disposed of, subject to observation. Great.
Not end. Not end.
Your Honor, for the record of the court, I am Srinivas S. Devati. I'm the appellant in this writ petition WA 983 of 2024. I do not have any lawyer, any law firm representing me in this writ appeal, and I represent myself as party in person in front of this honorable court. Again, for the record of the court, I'm a citizen of India. Your Honor, I'm here to receive the interim prayer relief orders listed in the writ appeal in the paragraph 27O, sequentially all the way until 27DD from this honorable court today. The reasoning being, I seek these interim relief prayer orders with reference to Annexure B, the orders issued by this honorable court, where the cause of action has already been recognized with all the documented evidence that has been submitted to this honorable court. And the cause of action has been allowed by the orders dated 14/6/2024 for writ petition WP 12356 of 2023. However, in the orders, the honorable court has given the respondent a time of 6 months to take the necessary action and issue the consent letter to initiate the original suit against United States Patent and Trademark Office. If the honorable court is going to grant similar time frames for taking action by the respondent for the interim relief prayer orders 27O to 27DD, say they give them granting them few weeks or few months of time, that is the primary reason that I request that these orders be granted today. Do not know if the time frames would be the same for all the prayer reliefs or would be different for each of the prayer reliefs for 27O to 27DD. Your Honor, I would introduce the cause of action. World Intellectual Property Organization is an organization which has 193 country members. Property rights of citizens across the world, especially across the other countries. One of their responsibilities is that they administer the Patent Cooperation Treaty, a legal agreement that is signed by over 156 world countries. It is one of the most popular treaties in the world. It provides invention patent rights protection for inventors across the PCT contracting states.
Lord, I'm sorry, Lord.
This
Before
PCT,
he proceeds with the merits,
this Patent Cooperation Treaty,
on the maintainability, can I make some submissions? On the maintainability, before he goes into the merits, not on the maintainability, can I make some submissions? Not only that, Lord, the appellant's grievance seems to be, Lord, against the US Patent Office. And he had earlier filed a suit without obtaining.
Taking some patent?
Yes, in respect of some patent, he has grievance against the US Patent Office. US Patent Office. So to.
Grievance against US patent?
Yes, US Patent. His grievance is against the US Patent Office.
He's seeking patent registered in US.
Yes, he seems to have some grievance against that. And he wanted to sue the US Patent Office and some of its functionaries in India. For that, he required consent of the central government under Section 86. Without that, he filed a suit. Suit was rejected. Thereafter, my lord, he wrote to us seeking consent, our consent under Section 86. In a 2-line order, my lord, we communicated to him that we do not accede to your request. That was challenged before the learned single judge, my lord, in WP number 12356. The learned single judge felt that our 2-line communication was cryptic and directed us to allow the writ petition. directed us to give a reasoned order. My lord has granted 6 months' time. My lord, we will do that. My lord, we are considering that we will issue necessary communication. That is as far as the annexure B, WP 12356 is concerned. My lord, he cannot have any grievance against that. As far as annexure A, my lord, there was another writ petition in which, my lord, the learned single judge, considering all these cases, has found that it is not at all maintainable. Now, my lord, in the writ appeal, he doesn't refer to annexure A order. He only gives reference to annexure B, which is in his favor. And then, my lord, kindly have a look at the relief sought beginning at page number 22. Lord, the appellant cannot go beyond what he had, what prayer he had sought before the learned single judge. But if your lordships looks at page number 23 onwards, please have a look at the headings. Lordships will get an idea what is the relief sought. Page number 23 of the writ appeal. Para 27, if your lordships would kindly see first. Para 27. I request the Honorable Court to issue the following orders, starting with the interim relief prayer upon the receipt of consent letters to address CPC. So he himself says, upon receipt of consent letter. We have not yet issued the consent letter. Para 27 at page 22.
The main petition. Main writ petition.
Main writ petition. No, I do not see, it is not produced. It should have been produced. But please have a look at the prayers. How are these prayers maintainable? For example, page, just two more minutes. One. Page 24. Page 24.
That's the main petition produced. We will not be able to understand. To produce the main petition.
And my lord, interim relief cannot be sought like this. He has to file separate IAS.
Your Honor, the cause of action is one and the same for both the writ petitions that were filed. The Honorable Court has already recognized and allowed the cause of action. So there is no question about challenging the cause of action once again, because the entire stack of documented evidence has already been produced to the Honorable Court.
The compilation of the appeal doesn't seem to contain the copy of the original writ petition, from which the impugn order of learned single judge arises, learned full stop, learned
Your Honor,
14 person shall produce on record the copy of the writ petition within
Your Honor,
within 10 days.
WP 13823 of 2023 has been produced in a memo enclosing a copy of writ petition WP 13823 of 2023 with all annexures and statement of objections filed by the respondent. I've already produced it to the Honorable Court and it is in the file. A copy of the same has not been given to the respondent because they already have received it as part of the
Person
petition.
admits in course of the submission that the copy of the petition, which is otherwise supposed to be part of the appeal memo, is also not given to the other side.
This memo enclosing the copy was filed on 9 July, Your Honor.
The requirement of giving copy of the petition and the entire compilation of the appeal shall be also met with before the next date. Stand over.
Your Honor, I already produced it.
Give copy to others.
The entire, the writ petition, it is about 1,300 pages or so.
After you file before the court, give copy.
All right. Your Honor, if I may, the cause of action has been recognized in the orders for WP 12356 of 2023, and the same were to be extrapolated for the subsequent other writ petition 13823 of 2023, Your Honor. I'll serve a copy for them, the entire copy. However, I would want to just state this fact set to the Honorable Court that the World Intellectual Property Organization administers the Patent Cooperation Treaty. And Patent Cooperation Treaty is a treaty that is signed by 156 world countries, including India. And it is this legal agreement that is binding 156 world countries, which is the central legal agreement on which this writ appeal is based on, Your Honor.
For the above purpose, stand over to 21st of August.
November 13.
Yeah.
Neeraj Shatri.
I'd want to present some of these facts about the Patent Cooperation Treaty and my PCT International Application, PCT US 2014-046619, Your Honor. That is the central agreement, the invention patent application, which directly connects this writ appeal to 62 world countries, and by way of Patent Cooperation Treaty connects to 156 world countries, Your Honor.
13.
like to continue to present this. I'll take about 20 minutes of time to present all the facts of this writ appeal.
Once you comply with the requirement, then we'll hear you.
21st of August.
Sorry for the appellant's counsel.
Yes.
Challenging the order of the learned single judge, my lords, dated 12th of June 24. Just a brief factual background of this, my lords. On 3rd of August 2017, the Karnataka Power Corporation Limited had issued a recruitment notification for about 620 odd posts in the cadre of assistant and junior engineer and some other posts as well. That's the written test, my lords, pursuant to that recruitment notification was conducted on 21st of January 2018. Now, can I just point out two documents, my lords, which may be relevant for the purpose of this appeal? My lords, may kindly see page 66 of the appeal memorandum. As kindly, before that, if my lords were to kindly see page 55. At page 50, annexure A is the recruitment notification. Page 55, my lords.
So what is the circular?
This circular, my lords, will find at page 259, annexure W. Was in short, the issue is this, my lords. There was an examination conducted in 2018, which came to be annulled by the KPCL itself because they were due to pendency of certain writ petitions where the examination process was challenged. Now, the KPCL took a decision to annul that exam and to conduct a fresh examination all over again. Now, the litigation was pending from 2018. Well, finally, review petitions came to be disposed of in 2022. In 2023, December, again, my lords, possibly due to the pendency of a petition where they were forced to file an affidavit stating when they would hold the exam was scheduled for February of 2024. Now, the limited grievance of the appellants is this. When the exam was originally held in 2018, our question booklet and the hall ticket specifically stated that there would be negative marking as well as the quantum of negative marking. So I was put on notice of the fact that if I answer a question wrongly, 1/3 marks would be deducted. When the fresh examination was decided to be conducted, unlike the previous time, it was this time outsourced to the Karnataka Examination Authority. In January 2024, my lords, the Karnataka Examination Authority itself, who had now been outsourced the task of conducting the exam, they themselves write to the KPCL asking if there should be negative marking. So, my lords, KEA itself was not entirely sure whether there should be negative marking or not. The KPCL writes back to them saying that, yes, there should be negative marking. Of course, all of this is inter-department. The applicants or the persons writing the exam are not made aware of it. Our hall ticket and our question booklet, unlike the previous round, of course, possibly the fault is not of the KPCLs this time, but possibly more of the KEAs. We are not put on notice of the fact that there is negative marking. So therefore, the appellants as well, in fact, there are writ appeals, I'm told, filed by other applicants as well. All of them write the exam on the premise that there is no negative marking. And as your lordships would appreciate, that makes a world of a difference. If I'm told that out of 10 questions, if you answer all 10, I will not negatively mark you. I will attempt all 10. But if you tell me that for a wrong answer, I will deduct questions, I'll deduct marks, then I will obviously pick and choose which answers to, which questions to answer and which not to. So therefore, my lords, in fact, as a result, my lord, statistically, out of about 18,000 people, I'm told, who wrote the exam, about almost 16,000 people have got below 35% marks. Of course, this is not a public interest petition where I'm not speaking for, but this is what has happened due to the Karnataka Examination Authority's actions. Now, in the impugned circular, lordships asked, at page 259, the exam is held in February 24. On 8th of May 2024, finally, we are told by the Karnataka Examination Authority that there is negative marking. 3 months after I've written the exam. Again, Malad, I'm stating possibly the power corporation may not be entirely at fault with this, because they were asked a question by the KE. The KE ought to have put us on notice because they were outsourced the task of conducting the exam.
So you're challenging after participation.
Yes, madam. Now,
That's a good ground.
yes, but now in fact, the learned single judge Malad has rejected my petition on two grounds. One, that I willingly participated and afterwards challenged it. Now, I only asked myself, I willingly participated on the premise that there would be no negative marking. I was not put on notice. So therefore, my lords, kindly see the timing of the filing of the writ petition. I did not wait for the.
You were not aware about the.
No, we were not, because on all fairness, when the first exam was conducted, I was told not in the recruitment notification, but in the hall ticket and the question booklet that there would be negative marking. This time, no such communication to the persons who wrote the exam.
Your appeal. Notice written. It will go to 24th September.
24th September.
My lords, insofar as the petitioner's contention that he was not aware, petitioner himself has instituted the previous 7 rounds of litigation in respect of this examination. Initially, my lords, KPCL cancelled the examination.
We'll consider on that.
Very well.
Now, could it be called along with writ appeal number 1160? Was my only request is this, let them proceed. They're calling for document verification. Now, my only apprehension is if they issue appointment orders, third-party rights would be created. So let them continue the document verification, but let them not issue appointment orders in the meantime. Because this writ appeal would become infructuous. My only, because once by 24th September, if they were, I'm told, my lords, recently they called for documents. I'm not, I mean, they're at liberty to call for documents. But considering the fact that for 6 years, my lords, they haven't appointed anyone, another 1 month, I'm sure they can wait.
We'll keep it earlier, 28th of August.
28th of August, great. 29th, my briefing council has some difficulty. 29th, along with writ appeal 1160 of 24th.
To be listed with.
Number 14.
Grateful. I'm sorry. Can we take out notice for the Karnataka Examination Authority on Mr. N.K. Ramesh? We'll serve a copy on Mr. Ramesh. I'm so sorry.
Open for learned advocate for the petitioner to serve copy of the appeal to learned advocate Mr. Ramesh, who normally appears for Karnataka Examination Authority in addition to normal mode of service.
Grateful.
14.
The appeal is by the veterinary university. There are 2 other appeals, my lords, connected, if your lordships could take it up. This is regarding the new pension scheme and
Delay is there.
delay is there. That's because the government, my lords, said,
Notice returnable on.
please,
Other appeals are kept when?
pardon me.
Other appeals are there.
There are 2 more appeals filed by the university.
Filed by, not on board.
It's not come on board, my lords, that's why.
So this can go to 12th September. Returnable.
Notice, madam. But the first and second respondents, my lords, the government can take notice. That's a government which is, they also take our stand only, though they are respondents in the writ appeal.
Learned additional government advocate Srimati Nilofer Akbar accepts notice on behalf of 2 and 3.
First and second.
1 and 2.
Number 15. MC Basuraj.
It's a delay of 255 days. Not the appellant is a conductor. But on certain charges, my lord,
There is a delay, notice returnable on September 26.
Complaints in contempt matters, number 16. To Srinivas V.
My lord, I appear for complaint in this case.
My lords, I appear for the accused undertaking to file NOC Vakalatnama.
You are filing Vakalatnama
Yes, my lords.
in order to enable learned advocate
My lord, in this case, my lord,
Vakalatnama on behalf of the
my lord, one
respondent and
submission, my lord,
23rd of September,
one submission, my lord, in this case.
24th.
My name may be diluted. B.L. Sanjeev.
Name of learned advocate Mr.
B.L. Sanjeev.
P.S.
B.L. Sanjeev.
P. Sanjeev Kumar.
Such Prashant
That
name may
there
be
are-
inside.
While notifying the contempt petition on the next stage.
My lord, let there be a short date, my lord. The reason is, due to non-payment of the GST amount, my lord, there was a direction. Employer has to pay the GST, my lord. In the instant case, my lord, due to change of law, earlier, my lord, it was a VAT. Due to change of law, my lord, the GST was not paid by us because it was a tender matter. When the tender we have entered into, it was a VAT period, my lord. Subsequently, GST was introduced. Now, my lord, in the tender, what we have quoted was price of a VAT. In pursuance to GST invention, my lord, it was 18% it made, and thereafter it became 28%. Therefore, we approached this honorable court that there be a direction for the employer, that is the BBMP, to pay the GST amount, difference in the tax. Now, my lord, this honorable court have given a direction for them to consider the representation and to pass appropriate orders and to pay the GST. Now, my lord, in the meantime, though there was a direction to pay within 6 months, they have not complied with it. Now, my lord, in the meantime, the GST authorities have seized my office also. And they have taken away all the materials pertaining to the tender work, what I have done to them. Now, my lord, they are going on, my lord, after filing of this contempt petition, whenever the matter is posted, they will issue one notice calling upon me to furnish certain documents. My lord, all the time I have replied to them. All the time I have replied to them. And my lord, last time I have told them very clearly which seizure mahazar I have given them. These are the documents what they have seized. Now, you being the employer, you have to get the information because I have done the work and I have given the bill. Everything duplicate will be with them, my lord. In spite of it, they are insisting me to give the duplicate bills and everything. They will be also be having the code. My lord, they are just trying to drag the issue. Now, my lord, in the instant case, there are two accused persons. One is executive engineer of the Bommanalli and one is executive engineer of the technical cell. Now, my lord, the Bommanalli engineer have gone on dragging by giving one after one other memo, my lord. Tech executive engineer have never replied to the show cause notice of the contempt also. Now, my lord, at least the contempt should be initiated as against the second accused also, my lord, because he has not responded till date, my lord. Till date from the date of filing of the contempt petition, my lord.
Secure instructions, my lords.
17, Vasant Kumar XP.
Short date. I'm sorry, previous one. Any date, my lord.
23rd September, 24th September.
Your Honor.
Yes, Mr.
For 17,
For the complaint, Lord,
Yes, Yes,
my lord, the accused has disobeyed the order of the learned division bench order.
you can't mention this in the middle of the proceedings of the court. We'll withdraw your certificate.
Page 29 of the impugn order may kindly be seen.
Yes.
The honorable division bench has directed the accused to deposit the make payment of arrears of maintenance digitally to the respondent till the month of February 2024 within 2 months from today. Well, after giving such direction, they failed to make the payment. Hence, the present contempt is filed. Now, my lord, he filed the counter affidavit saying that, my lord, I have suppressed the material fact, the pendency of the execution petition. May kindly read the page 25 of the order sheet. He himself has produced the order sheet of
You
the
have not paid the amount.
Pardon me?
You have not paid the amount.
You have
No,
paid,
my lord, still you have not.
No amount.
No, my lord.
we have paid 3,80,000 rupees deposit before
That
the
is, my lord,
appeal court, which has been withdrawn.
After
I
time
have
of
produced the order
admitting
sheet of the
MFA,
appeal.
The MFA court has directed to deposit the 50% of the amount. After giving such directions, he has deposited the 3,80,000.
Not sir. The serious issue has been raised before the execution.
No, my lord, simply has made allegation that, my lord, here the wife has got remarried, but he has failed to establish his rights before the execution court. He himself has filed to drag on the proceedings, kindly page 25 of the order sheet may kindly be seen. He himself has produced that. He himself has filed memos saying that, my lord, not to pronounce his judgment because the MAP is likely to be listed on 18/1/2024 and likely to be decided on 31/1/2024. To only drag the proceedings, he himself has filed the memo before the execution court not to proceed because the MFA is pending. MFA has concluded judgment has been passed directing the respondent to pay the monthly maintenance.
May I make submission? Lords, the judgment and decree, my lord, passed by the, my lord, family court in MC number 3411 of 16. Lord, the family court has specifically granted, my lord, interim maintenance subject to, my lord, until and unless, my lord, the wife become disqualified to receive the amount. There is a condition in the order.
No. Where is the decree?
May I?
Where is the decree?
Not the page 29, my lord. The
29.
order passed by the division bench.
Judgment in decree MC 3411.
Yes. This is page 59.
Lords, may I make some? Lords, may I make not submission? Lords, the trial court, my lord, granted my lord permanent limine. I'll read the order. Petitioner husband is further directed to pay maintenance of rupees 40,000 per month to the respondent till she becomes disentitled. Lord, till she becomes disentitled means, my lord, until she becomes disqualified by getting a remarriage. My lord, he immediately after the decree, my lord, he filed execution, my lord, on 8/9/21 annexure, my lord, A R1. Kindly peruse annexure R1 notes, page 6. 8/9/21, my lord, he filed an execution petition before the family court. My lordship, may kindly see in the said objection, my lord, execution, I filed objection, page number 9 of the counter affidavit. Kindly peruse para number 2, my lord. My lord, the accused herein, my lord, has taken up a contention that she got married subsequent to decree and she become disentitled to receive the amount. Therefore, she is not entitled for any maintenance after, my lord, this date of, my lord, this qualification date. Now, your lordship may kindly see the order sheet produced by me at page 21. This is the order sheet with the execution petition court. My lord, may I read the? The trial court noted the objection stating that she disqualified to receive the amount. In the meanwhile, my lord, she has withdrawn 3,80,000. Page 21 notes. Order sheet of the execution petition. Lords, page 21, execution petition order. Lord, JDR present, advocate for DHR files a memo with online copy of the order passed with the Honorable High Court, WP number so and so dated 3/3/23, perused. Interim order dated 11/10/22 is not extended. Advocate for JDR present, files affidavit of JDR with a memo of enclosures regarding order passed in MFA 23231 of 21. It is submitted by the advocate for JDR that DHR had already married and amount of 3,81,000 MFA 323121 is withdrawn by DHR. So DHR is not entitled for claiming permanent alimony and she has received excess amount. On the other hand, advocate for DHR has taken steps and prayed to issue attachment warrant immovable property for the balance permanent alimony ordered accordingly. So it is necessary to conduct inquiry regarding the allegation of the JDR. Lord, execution court conducted an inquiry with regard to whether the decree holder has become disentitled to receive. Now, after hearing the argument, after conducting inquiry, matter is reserved for orders and it is posted for orders on 13/8/24, milords. My grievance before the execution court is she is only entitled for 2 months maintenance. She got married. Therefore, I have paid excess amount of 3,80,000 to her. Therefore, milord, she has to refund.
Allegation, my lord.
No,
Please file such application to drag the proceedings. He makes such allegation, my lord.
So he is
when the execution court has posted for pronouncement of orders, he himself have filed a memo saying that not to pronounce the. Please.
Following directions are following directions issued by a single judge while dismissing the appeal came to be issued. As per following directions came to be issued by a single judge in his order dated so and so 28 March 22 while dismissing the appeal. So direction number 2 and 3, page 28 and 29.
On page 20, if at the order sheet of the execution could may kindly be seen, Lord.
The respondent is under obligation as per the above directions, to pay the arrears of maintenance to the appellant is under obligation to pay the arrears of maintenance to the respondent at the rate of ₹40,000 till the month of February 2024, as reflected in the above directions. It was stated, where is that interim?
Page 73, my lord. Order of releasing the amount has been passed by the division bench. Page 73. IA number 4 for releasing the order has been allowed filed by the.
How much you have paid?
3,80,000 rupees paid.
It is the case of the respondent that towards the maintenance, ₹3,80,000 already paid. Good stuff. The appellant shall produce the statement of calculation showing the amount towards maintenance due according to him pursuant to the directions of a single judge after adjusting the aforesaid amount which is received.
No, after
Received or
passing
not?
this order, division bench order.
80,000 received or not?
No, my lord, after passing the division bench order, he has not paid any single NP, my lord.
My lord, the order sheet of the division bench, page 74 clearly reflects, kindly see.
You will kindly peruse the page number 20 of the division bench order.
Page 74 may kindly, he himself has
No, my
received it. Amount is transferred.
After disposing the MFA.
It's a division bench order sheet. my lord,
After
I'm pretty
disposing the MFA, there is a specific direction.
Showing the amount due but you.
Pardon me?
You give your statement of calculation.
Please. My submission before this court is only this.
It was not pointed out to learn a single judge that this amount was paid.
No, my lord, it is in the division bench. Before division bench only, my lord, amount is deposited. My lord, I filed early for early
No, my
hearing.
lord, after
Division
time of
bench, my lord,
admitting the appeal.
passed an order.
Even after that payment, some amount will be become.
No, my lord.
No, let
No,
me-
my lord, after
let me
disposing the
clarify.
division bench order.
When I filed an IF for early hearing, division bench passed an order subject to my lord, deposit of 50%. I will allow the early IF for early hearing. I deposited the amount. IF for early hearing allowed. He filed IA. Division bench allowed him to withdraw an amount. Then he filed IA number 4. Registrar has transferred the amount digitally to his account. Page 74. Division bench order sheet is produced before this. It has been denied by them. Page 74 may kindly see.
To produce your
No, no.
calculation,
No,
then
my lord, see,
For
that
the
is
moment, may
subject
kindly
to
see.
condition of admitting the appeal. He has deposited the amount. After this,
you produce your calculation.
please, I'll put the
How
calculation.
the
Memo
amount paid,
of-
Then we'll see.
In the
There
meanwhile,
is a madam 17 lakhs is.
grievance is, he filed an execution. Execution court has reserved the matter for orders on 13/8. Without disclosing the fact that he filed execution, he filed a contempt. Either he should withdraw the execution.
No, he's a make.
Now the two parallel proceedings are
Kindly peruse the page number 25, my lord.
parallel proceedings are pursued for execution of the one decree.
What by respect
The
submission,
written-
but kindly peruse the
in the
page number
MFA
25, my lord.
only.
He himself filed a memo.
Will produce.
Pardon me?
When you will produce?
3 days, my maker.
3 days.
Yes.
Stand over to 20th August.
Please do. Much obliged.
Number 18. Christian Basuraj.
My lord, I am appearing for the complainant in this matter. My lord, the compliance affidavit is being filed by the state, my lord, hence contempt petition may kindly be dropped, my lord.
On the ground that why?
They have complied, my lord, they have complied the, my lord, order passed by the learned single judge, my lord.
Learned advocate Mr. H.N. Basavaraju appears the video conferencing to submit that the contempt proceedings filed by the complainant may be dropped since the compliance is obtained. In view of the statement and the request, the present petition is disposed of as not surviving.
Much obliged.
This number 19. Vital BR.
Lordship. What's the mic? Lordship, I filed an impleading application in this petition, my lord. The two of the applications I filed in which the office objections are been. Lordship, I'm a cooperative society formed by the order of the RERA authority, my lord, which in fact, my lord, is formed to take over the project. Lordship, if Karnataka Apartment Ownership Act get enforced, my existence will become invalid, my lord. And your lordship, since the RERA has been enacted under the same items of the third list, my lord, the concurrent list, the Apartment Ownership Act 1972, my lord, is deemed repeal. This fact has been, my lord, while striking off the West Bengal's housing and, the HERA, what they brought it, WB HERA, my lord. The Supreme Court has looked into the repugnancy, my lord, under Article 254.
Who is for the petition?
We are happy for the
What is the
petition.
matter?
My lord, this matter is with pertaining to the deed of declaration. A deed of declaration under the Karnataka Apartment Ownership Act is a declaration of the status of the property and the details of the flats, apartments, unit, the common area, all the details are furnished in that under section 11. The issue is twofold. One is with regard to the deed of declaration being registered, required to be registered under the act in a particular book in the sub-registrar office. That is not available and it has been continued to be registered. One aspect of the matter. The other aspect is this deed of declaration itself, once it is registered, is being used as a body corporate for the purpose of running the establishment. But more than that, in view of section 17 of RERA as well as the COFA, which are all in pari-materia with various enactments all over the country, 17 as well as section 11 of COFA, this Karnataka Apartment Ownership Act, those enactments, they envisage that the entire common areas shall be conveyed to the body corporate. Now, for that purpose, the body corporate should be in existence and should have a structure and it should be a juristic person. Now, all that apart, before the IS can be allowed and we have no objection to all that, I'll just read one small paragraph of the state government's objection, only one paragraph, to point out what they have to say and they support us. Paragraph 20 of their objection says thus, 4 lines. It is submitted that the formation of the Apartment Owners Association based on the mere registration of the deed of declaration that is done with the sub-registrar's office, thereby claiming them to be a body corporate or juristic body, and opening of bank accounts, obtaining PAN card, etc., are not as per the spirit of the said act. Hence, respondent number 3 cannot be blamed. This matter has to be heard, my lord. So the state government also understands the issues that we have raised and they file an objection in support of this. This was filed about maybe 2 years ago, I think. So therefore, the matter has to be.
So today we grant this impleadment.
Yes, my lord.
Yes. In fact, there's a judgment of your lordships. Your lordships, my lord, have passed an order saying that it has to be only in, my lord, under the apartment ownership.
That we will take
That
it up
order
with the
is passed.
final.
Yes, my lord.
That
Page 2. And Justice Oak's order also, my lord, as he then was, Chief Justice of this court, my lord, that is also there at page 65. Page 2 is your lordship's order.
That is where, my lord, my entire existence will be questioned. Here, my lord, I've taken over the project, which is abandoned by the builder. And that was allowed under the provisions of RERA, my lord, section 8 of that, which permits me. And if Karnataka Apartment Ownership Act is enforced upon, my existence becomes nullity. My lord, my respectful submission is, my lord, when after the RERA has been enacted, this act does not survive.
But
however, no document.
Today, who are you?
My lord, my name is Purnima P. Salian.
Impleading, who are you?
Me, my lord. My lord, I'm impleading applicant number 16 and 17. I have to verify with the cost title, my lord. There is some issues. I don't know the number of impleading, the recent impleading applications happened. So in the office objection, I'll comply that, my lord.
Which is your IA?
IA 1/23 and 1
You be
24.
sure about your IA. What is your IA?
My lord, IA was IA 2/24 and 3/.
Honored Advocate Mr. So and so 6 impleadment, however, is not aware about the number of IA is filed. To be listed on 20th September.
Please.
My lord, may I make a submission? My lord, I'm listed in point number 3, Purnima P. Salian, and I have an objection. I had filed my application for party in person. I'm assuring the court that I will comply with the objection and allow me to implead as a party in person.
On that day will.
Thank you, my lord.
Still number 20, Raghavendra G. Gayatri.
So I filed IA to recall the preemptory order, my lords. It was dismissed for non-compliance of office objection. I have complied all the office objections, my lord.
Restoration.
My lords.
Restoration.
Restoration, I guess.
Restoration, delay both.
Delay, my lords. Delay in filing restoration. Preemptory order came to be confirmed, my lords.
So common order in IA 3 of 24 and 4 of 24. Third learned advocate Mr. Raghavendra Gayatri for the then first order in IA number 3 of 24. Third learned advocate Mr. Raghavendra Gayatri, this application is filed for condoning delay of 44 days. Condoning delay of 44 days, which has taken place in filing the application for recalling, which is IA number 4 of 24. Full stop. In the accompanying affidavit, the delay is sufficiently explained. Delay is properly explained, sufficient cause is made out. Delay is condoned, application allowed. Then order in IA number 4 of 24. Delay in filing this application is condoned as per the above order. Paragraph, the present application 6, recalling of the order dated 8/4/24, whereby the writ appeal was dismissed for non-removal of office within stipulated time. Full stop. Learned advocate, Mr. So and so, in course of the hearing submits that the left out office objections will be removed within the time which the court may now grant. Paragraph. It is right that the party should be allowed to litigate on merits rather than being thrown out on technical consideration. In this view and in view of the statement made by learned advocate that the office objections will be removed, this application is allowed by recalling order dated 8/4/24 and restoring writ appeal number 528 of 24 to its original file, along with all the orders subsisting therein, on condition that the remainder office objections
I have
will be
complied.
removed.
I have complied every office objection.
2 weeks if not complied with. If the objections are complied with, office is liberty to official list the writ appeal for admission here.
Deeply obliged, deeply.
non-filing in contempt matters, cell number 21, so SB Mukkanappa.
The respondent, I have filed my Vakalat yesterday, my lord. 2 weeks time may be granted to file my reply. Yesterday I have filed my Vakalat. You will go to 18th of September.
This cell number 22.
I appear for the
AM Lata
complainant in
issue.
this case. Yes. I appeared for the accused and I am filing my objections to the petition. I served the copy also to the other side. I am humbly praying that if I can file my statement of objection across the table, I request permission to file. In this case, your lordship had ordered for an interim arrangement on 29/7 to take out the child from 11:30 to 1:30 like that. This Saturday, he took the child out and child was comfortable with him and the child enjoyed the company of the father also. And what I submit. Four weeks, so that,
That is reasonable.
yeah, for 4 weeks later on, it may be posted if the child becomes comfortable with him.
Correct. The following order was passed on 29/7/24.
As per the child's wish, if the child is ready and willing to go, we don't have any
The
problem.
entire order.
We have provided the another cell, the
Today when
mobile to the
proceedings came
child
up,
to contact him directly.
learned advocates for the party stated that as observed in the aforesaid order, the parties had met and the child had an occasion to interact with the father. Full stop. It was claimed. it
Provided
was
the
claimed
child
on
is
behalf
ready
of
and
the-
willing to go, my lordship.
It
was
is
claimed.
ready, child
Provided the child
enjoyed his
is ready and willing
company.
to go, we don't have any problem.
No, no, she should not come in the way of
No, we
creating
won't.
any obstruction or anything.
My
Let it
lordship,
continue for another.
My
few
humble
weeks.
submission, we have given a different new cell phone to the child and a ready access to the father to contact him anytime. So he is directly contacting to the child and they are talking and they will decide. If the child says, I want to go, we don't have any problem. We will follow up the court order. We have respect for the court order. Provided the child is ready and willing to go, that's all.
It was claimed that the child was comfortable with the father. Full stop. Learned advocate Ms. So-and-so, the complainant subject requested that since the directions have worked from a same arrangement may be repeated for next week to continue for next 4 weeks. Full stop. The request is reasonable. We reiterate the direction made in paragraph 4, 5, and 6. 4, 5, and 7. So every Sunday, the state directions will operate for the next 4 weeks on today, 10th August, 17th August, 24th August, and 31st August. The proceedings may be listed next on 4th of September.
My lordship, the child is there before the order.
Number 23.
Much obliged.
Inisha has 14.
So far as accused number 2, compliance affidavit has been filed.
I don't
My-
have the benefit.
23.
I don't have the benefit of the copy of the petition. Last date, I undertook notes that I will file Vakalat. I filed the Vakalat. Copy is not served to me. I'm making a
Lordship?
request.
My lordship, if I may make a submission, I am the complainant herein. I have served a copy to the opponent through his email address, and a message has also been given to the council that the copy of the application has been served to them.
Notes, I have not received notes. I have not received.
My action before this court is because of the rains and the landslide, the train to Bangalore has been cancelled off. So if an adjournment.
Because I have not received notes. I have the WhatsApp message. I can just hand over to the court.
So it again.
It's
That's,
an email.
So far as state, my
At
lords,
least a copy be served. The rival claim about the service of the copy of the petition to the respondent. It is directed that the fresh copy shall be served to the respondent by the party or the petitioner party in persons to be listed next on 25th of September.
Great.
Much obliged, my lord.
Number 24, Mr. Somsekhar RP.
September. 24. 26 September.
so affidavit is ready, my lords, I'll get it filed.
24,
That's up.
number 24, RP Somsekhar.
Which one?
That's the, it has been complied with, my lords. The affidavit is ready, my lord. We have made the entries.
It will go, nobody is present.
Please.
Serial number 29.
29.
Pray for 2 weeks time, my lord, in this I have filed.
29, all right, 26th of September.
My lord, serial number 25, my lords. Already compliance is been, matter may be disposed of, my lords. Serial number 25, my lords.
Learned advocate, Mr. So-and-so, Mr. Arvind stated that the order under contempt is complied with and that the proceeding does not survive. In view of the above statement, contempt petition is disposed of as not surviving.
Obliged.
Serial number 27, my lord. Today I
27.
filed the Vakalat, my lord, 3 weeks time to grant
3 weeks,
my version, my lord.
24 September. Yes.
Serial number 41, my lords, I am undertaking to file the wakalat on behalf of respondent.
24,
41,
40.
WA 138 of 24.
The other side is informed.
I have not yet informed.
Do it. We have to inform the other side. You'll grant time, but you inform the other side. After you revert back to court master that you are informed, and the date will be given of that choice.
Yes.
This benefit has been paid.
Madam, the proceedings will continue in the afternoon? Madam, will proceedings continue in the afternoon? Madam, will proceedings continue in the afternoon? Court officer.
With the Lordship's kind permission, seal number 58, cause list number 1. I request your Lordship to kindly have it on the day after tomorrow.
Day after
Tomorrow. It is not any inconvenience for your Lordships.
What is that urgency? PIA
PL man,
regarding
the lands belong to the Bhudana movement lands. Lands which has come to the, under the Bhudana scheme. In the movement spearheaded by the author No Babbage.
not day after tomorrow.
Highly opposed.
It not day after tomorrow. It will go to 29th of August.
My lord. Serial number 53, my lord. The time may be granted.
53.
53, my lord.
So when do you want?
After a week, my lord.
After a week, 22nd August. 22nd August.
Oblige, my lord.
Yes, please.
So how much time will it take?
Well, I won't take much time, maybe 15 minutes.
So first is then here. Any other 230 matter is?
So list 2, seal number 4, Rajav Kumar Patil.
You all have completed. Your petitioner was born on 9/4/2006 at Sikandrabad, the state of Telangana.
9/4.
2006 in the city of Sikandrabad in the state of Telangana. She acquired British nationality in 2012. And on 14/2/2012, the British government issued a British passport to her. 14/2/2012. Till 4/12/2018, she was in Britain. And effective 2019 onwards.
1 second. Little slowly.
I'm sorry, I'm sorry.
Passport was issued
I mean, passport was issued on 14/2/2012.
12.
Yes, Lords.
Then
She stayed in Britain till 4/12/2018.
4/12/18.
4/12/18, yes, Lords.
Yeah.
And 2019 onwards in the city of Ballari, she has studied till date. Her parents also acquired British citizenship in 2012. And in terms of Section 9 of the Citizenship Act 1955, the moment she acquires the citizenship of another country, her citizenship of India terminates. So with effect from, although she was born as a citizen of India, she has ceased to be a citizen of India effective 14/2/2012, on which day she obtained the British citizenship.
Yes.
Lord, admittedly, the petitioner holds a OCI card, And by exercising powers under 7B, the central government has conferred certain benefits. And one of the benefit is regarding admission to certain competitive examinations. So the petitioner as a OCI cardholder can only exercise those rights which are conferred to her as a OCI cardholder in terms of the notification issued by us under section 7B of the Citizenship Act.
It is 4-3,
I'm sorry, what?
4-3-21.
Prior to that, there were 2005, 2007, 2009. Look, between 2009 and 2021, we made a significant difference. We confined the effect of it only to the NRI quota. Till then, we gave parity for a OCI cardholder with a non-resident Indian. And a non-resident Indian would mean a citizen of India who's residing outside. So we literally gave parity with a citizen.
So he can exercise those rights which are available under the notification.
Yes, that is my submission.
Notification are issued under
Section 7B of the
7B.
7B of the Citizenship Act.
Yes.
By the 4/3/2021, we tweaked down the effect of the notification to say that an OCI can claim a right only over the NRI quota. But my lord, that has been whittled down by their lordships of the Honorable Supreme Court. And the latest position is that since the petitioner was born and obtained the OCI status prior to 4/3/2021, she would get the benefit that existed prior to 4/3/2021. Prior to 4/3/2021, the position that
14.
4/3/2021, the position prior to 4/3/2021, which means that she would have to be treated on parity with any citizen of India as far as the effect of the notification issued under 7B is concerned.
Prospective.
No, the Honorable Supreme Court said we have to interpret it prospectively. But since she had acquired the status prior to 4/3/2021, my lord, her relief in prayer E, my lord, prayer E may have to be allowed. The relief sought in prayer E. Lord, if your lordship would turn to page 30. Issue a writ of mandamus or other appropriate order direction directing respondent 1 to 3 to permit the petitioner to appear for the online seat allotment process in the counseling of UG NEET 2024 for medical dental seats. Page 30, my lords, clause E. Probably not. I would club relief E and F together, and I would say that the petitioner would be eligible to participate in the examination and seat selection process. But my lord, the reasons given, I do not concede. By virtue of the judgment of the Honorable Supreme Court in WP 891, the petitioner would be eligible for relief in E and F. But not by virtue of, my lord, in F, the reason given is that she has acquired citizenship by birth and descent. We don't concede that. By birth, although she had secured Indian citizenship, with effect from 14 to 2012, she has ceased to be a citizen of India. By virtue of the judgment, the interpretation given by the Honorable Supreme Court to our notification dated 4/3/2021, she would be eligible for participation and in the seat selection process. But, my lord, as far as the other reliefs are concerned, my lord, there is a challenge to that clause 6(1). My lord, how is the petitioner affected by it? By virtue of the Honorable Supreme Court judgment, my lord, she may be permitted to participate in the seat selection process, but she cannot question clause 6(1). Clause 6(1) is in line with our notification. So nothing wrong with clause 6(1). if I may take your lordships to clause 6(1), my lord, at page number 52 of the writ petition.
So that clause 6 is that no candidate shall be eligible for admission to the government seats.
Yes, it says eligibility of OCI-PO for the government seat shall be as per the directions of the government. Now, we have issued directions by virtue of the notification dated 4/3/21. Subject to its interpretation as made by the Honorable Supreme Court, it can be done. But there is no ground for striking it down. Which is why, my lord, the fundamental premise on which I am building my case is the right of the petitioner is only under the notification that we have issued under 7B of the Citizenship Act, as interpreted by the Honorable Supreme Court. Beyond that, my lord, the petitioner cannot say that the entire clause has to be struck down. If the relief were to be that it has to be interpreted in the light of the Honorable Supreme Court's order, my lord, I concede. Therefore, my lord, prayers A and B and C also would not survive in my respectful submission. Honorable Supreme Court has not struck down our notification. Our notification is protected. The Honorable Supreme Court has categorically said that the central government has got the right. On the application of the doctrine of promissory estoppel, their lordships have decided to give a beneficial interpretation to those who had admitted their children in schools in India prior to 2021. The second limb of my submission would be in respect of.
So you are saying that only 4 corners of 4/3/21 will apply. His case can be considered within 4 corners of this 4/3/21 notice.
Yes, subject to.
As interpreted by.
Yes, my lord, yes.
Yes.
Then, my lord, my second limb of submission would be in respect of the interpretation of Article 371J. My lord, the writ petitioner appears to claim that because of domicile and having birth by descent, he is eligible for the reservation. My lord, my respectful submission is, before that, my lord, may read once for your lordship's benefit, Article 371J of the Constitution. Special provisions with respect to state of Karnataka. Clause 1, the President may, by order made with respect to state of Karnataka, provide for any special responsibility of the governor for A, establishment of a separate development board for Hyderabad Karnataka region, with the provision that a report of the working of the board will be placed each year before the state legislative assembly. B, equitable allocation of funds for the development expenditure over the said region, subject to the requirement of the state as a whole, and equitable opportunities and facilities for the people belonging to the said region. My lord, I would emphasize on the expression belonging. People belonging to the said region in matters of public employment, education, and vocational training, subject to the requirements of the state as a whole. Clause 2 is important. An order made under subclauses C of clause 1 may provide for A, reservation of a portion of seats in educational and vocational training institutions in Hyderabad Karnataka region for students who, my lord, I would once again emphasize, belong to that region by birth or by domicile. My lord, this belong would mean that some sort of an association with that land, which can be achieved only by citizenship. It cannot be, if I'm a foreigner and I come to Karnataka, if I stay here to learn yoga, and if I manage to stay here by some means for 8 to 10 years, I don't belong here. I may be staying here, I may exist here, I may live here, but I don't belong to this region. Therefore, the expressions by birth or by domicile will have to be understood in the light of the expression belong to that region. Now, I would say belong to that region would mean only by citizenship. So what it effectively means is citizenship by birth or by domicile. And that interpretation should exclude anybody who is not a citizen of the country.
So you're reading something
I am interpreting the word belong to.
by in interpreting or reading something, adding the word citizenship.
That's the only meaning, my lord, that is the, otherwise, my lord, it may not make sense. Otherwise, my lord, it will throw open to anybody who visits this country, any foreigner who would visit this country, lives here for a certain period of time.
So you are trying to say that he can be said to be belonging to only in the circumstances where he is a citizen by birth or by virtue of domicile.
Yes, but otherwise, my lord, we'll take the example of the petitioner. The petitioner does not belong to that region by birth. So the petitioner was born in Secunderabad, lived in UK till 2018. For 12 years of her life, she lived in UK. Obtained citizenship there. But between 2019 till date, for a period of 6 years, as a foreigner who, by virtue of the notification issued by us, or rather by conferment of the OCI status, by a notification issued by us in terms of section 7A, has domiciled here for the purpose of study. So can such foreigners who visit this country for the purpose of education, for anything, can it be said that they belong to that region? My respectful submission is no. So the word belong would indicate that you should have some sort of an attachment to that particular region, and which attachment can be only achieved by citizenship. Therefore, my respectful submission is that the relief sought under prayer D, my lord, does not survive for consideration, would have to be rejected.
So they are saying that they are equated with or treated at par for the purpose of educational admission.
Yes,
With
yes.
citizens
That is under the notification issued by under 7B.
in general category.
Yes.
Now that notification, then they will say by necessary extension of logic that wherever there is a general category of citizens entitled to some benefit in relation
No,
to
my lord,
education.
I would say not
So they want the extension of equality.
no, that extension, my lord, which is statutorily conferred. By notification that parity is confirmed. My lord, what is a parity conferred by a notification cannot be extended to a constitutional provision. That parity with an Indian citizen is by a notification issued by an executive fiat. One, the conferment of the OCI status under 7A, and the second one, conferment of parity for education under 7B of the Citizenship Act.
Typically only gives a concept that you are at par with.
Yes,
citizens.
that is only good. So that cannot be
Okay.
taken backward to the Constitution.
Why not?
It cannot be. There should be a provision built in the Constitution, not what the government issues for a specific purpose. We have issued this for a specific purpose.
Specific purpose is to admit the students.
No, reservation is not part of our notification. By our notification, we have not touched upon the reservation in educational seats at all. It is merely a parity to participate in some competitive examinations, not of reservation in educational institutions. Reservation in educational institution is a constitutional concept, which I could not have done by issuing an executive order under the Citizenship Act. Not had I done that, somebody would have challenged it and it would have been struck down. I mean, it would have been clearly ultra virus. I, as the central government, if I had touched upon reservation in my notification issued under 7B.
Parity is not given to.
Parity, yes. Parity is only to participate in competitive examinations. Cannot be extended to reservation of seats in educational institutions.
This is a parity to only participate.
Yes, but to participate for selection in the selection process.
To compete.
Yes, in the selection process. To appear in competitive examination and to participate in the selection process.
Let us see this.
Lord, my stand as central government is, I have no rights to touch upon the concept of reservation when I issue a notification under 7B of the Citizenship Act. The petitioner cannot confer that power or jurisdiction on me. Lord, I have exercised powers under the Citizenship Act, Lord, which deals with issues of citizenry. Who is a citizen? What rights he can enjoy? That does not touch upon the reservation at all. So if 7B is considered to give reservation, or rather the extension of that, the parity there, if it is taken to reservation, then it will be clearly ultra vires beyond my jurisdiction.
So 7B itself cannot be extended to.
Yes.
371.
7B will have to be confined merely to the participation in competitive examination and the seat selection process, not for reservation of seats in education institutions. But there are two different concepts.
So CIE recognized as per section 7B.
Yes, please.
Is a class which for all purposes would fall outside 371J.
Yes, please. Yes.
So they can't connect themselves.
They cannot connect. That's my submission.
That is your-
They cannot connect. Yes.
Yes.
And moreover, Lord, the 371, Lord, I'm sure my learned friends appearing for the state have taken a lordship through that. The object was to take care of the existence of social backwardness and other things. Lord, it should be, I mean, these are people, the petitioner, my Lord, is a citizen of Britain, has come here for studies. They are beneficiaries of the social security provisions in their country. We have no control over them. After the studies, they may go back to their country. And they will, in no way, they will help us uplift the backwardness of that region. So can they come here and take benefit of a reservation meant for uplifting the backwardness of that region? In what way would they contribute in uplifting of the backwardness of that region if they are allowed to study here? We can't put them under bond to stay here and uplift the backwardness. They are citizens of other country. Once their education is over, they may go back. Therefore, my Lord, to sum up my submission, apart from giving the benefit of the interpretation of the notification dated 4/3/2021, my Lord, as laid down by the Honorable Supreme Court, and a right that they derive, that the petitioner gets to participate in the selection process, no other relief can be considered as sought by the petitioner. All other reliefs will have to be rejected.
So they can be allowed to participate in the selection process.
I'm sorry, ma'am.
They can be allowed to participate.
Yeah, the petitioner, as per the Supreme Court judgment, Lord, they are eligible to.
No, they want
In general.
Really,
In general.
that is not their prayer. They want in the that
No,
Hyderabad.
no, in general. In general only.
Your prayer is also not that specific.
No, my prayer as far as Hyderabad, Karnataka is very specific.
Allah,
I've thought
apart
for
from, apart from Hyderabad, Karnataka.
Is general. I am thankful to the learned additional solicitor general. He has considered also.
So your prayer is general.
General plus Karnataka, Hyderabad, Karnataka general.
Plus, it is a separate prayer.
General is one.
D में है.
D. Prayer D.
Yes. Correct.
He has sought for both, my lord. There are two very, very distinct reliefs. Yes,
Earlier portion he concedes. The latter portion he says no.
precisely. My lord, my learned friend is.
Mr. Kamath is saying that you can participate
Yes,
along with citizens in general category.
yes.
That I, as it is get it.
And the
Straight away I
right-
get it.
And according to him, the right ends there.
Yes, yes, that is what they are all saying. The right ends there.
Mhm.
Precisely. The right ends there.
I think cancel cover again. ಇದು ಓದಿದ್ದೀರಾ? Lord, there is on the domicile, there is one judgment of single judge of a Patna High Court, persuades you, Lord, it may be of some benefit.
So that's your right is the right, in a way you are saying that it is right to participate.
Yes. Like any other citizen,
As a citizen.
like any other citizen. Although the petitioner is not a citizen, by our notification, we have said we will treat you as a citizen. Lord, for example, if we look at the clause 1 under
What about that section 4(3)
I'm sorry, what?
residential order, that which is that section 4, concept of domicile,
Government order, state order.
government order, state order.
Oh, that?
They are saying that they fall under section 4, small Roman 3, to become domiciled person, to be entitled to. That is the another inroad they want to make.
But I have not yet examined this, not I lot. I may need some time on this. But my lord, there is one judgment which, my lord, rendered by a single judge of the Honorable Patna High Court, where, my lord, there was an interpretation of the Foreigners Act, and the expression domicile fell for interpretation. Para 14 and 15 may be relevant. Where, my lord, his lordship placed reliance on a Supreme Court judgment. Para 14, my lord, that. The learned advocate for the petitioner then relied on a decision of the Supreme Court in Central Bank versus Ramnarayan, AR 55, SC 36, which deals with the question of domicile. This decision was no help in this case because domicile is different from citizenship and significance of the two words is not identical. A person may have one nationality or citizenship and a different domicile, or he may have a domicile but no nationality. Ordinarily, domicile has not the effect of altering a person's nationality. In a state, a person may be a member of a civil society alone, as distinguished from political society. This membership of the political society determines his political status or nationality, on which depends his permanent allegiance or personal association to his sovereign. His membership of the civil society of a particular locality, that is, his domicile, determines his civil status. In other words, domicile implies connection with a territory, not membership or a community, which lies at the root of the notion of citizenship or nationality. Not every person with a similar domicile is citizen or nationality. He may be stateless, that is, without any nationality. Distinction between two words is also apparent from Article 5 of the Constitution. That article lays down as to who shall be a citizen of India. It provides that in order to be a citizen of India, at the commencement of the Constitution, a person must not only be domiciled in the territory of India, but in addition to that, he must have been born in the territory of India, or either of his parents must have been born there, or he must have been ordinarily resident in this territory for not less than 5 years immediately preceding such commencement. Therefore, my lord, to sum up my submissions, the petitioner at best can claim parity with the citizens of this country. And my lord, in our notification, we had said that it will be confined only to NRI quota. Now that entire general quota is available to the petitioner. That's the advantage that the petitioner gains by virtue of the Honorable Supreme Court judgment.
Entire general quota means?
If we give, my lord, minus the Honorable Supreme Court's judgment, the petitioner would have been eligible to lay a claim for the seats reserved only for the NRIs, which would have been confined to only 15% of the total quota. But now the entire general merit gamut is open to the petitioner. So there is a wider pool of seats available to the petitioner. One last point, my lord, even in the notification of 4/3/2021, my lord, we have inserted a notification, page 82 in the writ petition. For the purpose of this notification, OCI cardholder is a foreign national holding passport of a foreign country and is not a citizen of India. Even this has not been disturbed by the Honorable Supreme Court.
Where you are reading?
My lord, I am reading page 82. Page 81 is our notification dated 4/3/2021.
Provided that the OCI.
No, my lords, at the bottom, my lord, explanation. Page 82 in the writ petition, page 82. At the bottom, explanation. For the purpose of this notification, the OCI cardholder, including a PIO cardholder, is a foreign national holding passport of a foreign country and is not a citizen of India. Supreme Court has not disturbed this at all. Their lordship said, it doesn't matter, you cannot suddenly change anything. So you cannot confine them only to the NRI quota. Give them the benefit of the entire general category. So that benefit the petitioner derives by virtue of the Honorable Supreme Court's order.
So 371J reservation is exclusively for citizens.
Yes, lords. Exclusive for the citizens is our stand of the central government is that the benefit of reservation is only for citizens.
Is your stand or it is coming out from something?
By virtue of, my lord, the interpretation that I have attempted to place before lordship, that the word belonging to that region, the object of insertion of 371, that is to uplift the backwardness. But how can a British citizen coming to India, studying here for 6 years, going to uplift the backwardness of our region? So therefore, my lord, from any angle considered, my lord, reservation cannot be, the benefit of reservation cannot be given to foreigners. I am grateful to you.
Not take much time, my lord, I just, one or two aspects. First thing, my lord, the learned additional Solicitor General has clarified at the very beginning that NRIs are Indian citizens is what he had submitted. My learned friend yesterday had made a submission that NRIs are not Indian citizens. If he insists or persists with that line of argument, I just wanted to clarify. They are treated as a class apart. But they are Indian citizens, Indian passport holders. So NRIs cannot be called as foreign citizens. They are Indian citizens. Very well.
Yes.
So first aspect on facts, my lord, which I wanted to clarify as per NRIs are Indian citizens. So we are not Indian citizens, so therefore we cannot be called as NRIs at all, or we cannot be clubbed with NRIs. They being Indian citizens are a class apart, totally different category. Now that the learned additional Solicitor General as well as the learned counsel for KA have clarified, I don't want to say anything much about it. They are Indian citizens. That's the clarification. Now coming to page 82 of my writ petition. The explanation. The
Page
learned
82.
82, page 82 of my writ petition. The OCI cardholder, including a PIA cardholder, is a foreign national holding passport of a foreign country and is not a citizen of India. This is what was harped upon. Straight away, I concede all three. I am a foreign national. I am holding the passport of a foreign country. I am not a citizen of India. All three things I concede. But what the apex court has said, both the learned counsel for KA as well as the learned, they have harped on this notification. When the Supreme Court says notification does not apply, there is no point in looking into that notification at all. Don't apply it. And if you want to apply it, undoubtedly apex court, my lord, has said we uphold this notification.
Which this 4-3,
My lord,
which notification?
the 4/3/2021 notification has been upheld by the apex court.
Correct.
But the question is of its application. So apply it only from 4/3/2021. Now, I have registered, even according to them, I have registered prior to that date. I have an OCI card prior to that date. So this notification, according to me, in my case, cannot be looked into at all. It has absolutely no application. Tomorrow, the minute its application, my lord, is postponed, or it is said it is applied prospectively, a child born in 2021 is 3 years old now. May take another 15 years for that child to become eligible for admission to either a medical or a dental or engineering course. 17 is the minimum age. So you have changed the goalpost. That is what the apex court repeatedly says. Till now you had one particular policy. Suddenly you have changed when all these people. So don't apply it to them. So there is no purpose. This is like flogging a dead horse. Issue has been settled by the apex court that it does not apply to us. Therefore, the question of looking into the notification or referring to any portion of that notification to show that it disentitles me does not arise at all. Undoubtedly, it is a statutory notification. Anybody who is born after 4/3/2021 has to satisfy, come within the four corners of that notification, not I. Now, if the same logic as has been submitted now is extended, if we have to come within the four corners of this notification, the question of considering me for the general category in all the other seats also will not arise. It is an absurd proposition to say that I'll give you the general seats elsewhere, everywhere. And this notification applies when the notification specifically bars me from contesting those seats. So there is absolutely no point in looking at this notification. My respectful submission is this notification, the issue of this notification, as far as we are concerned, is a closed chapter. Apex court has authoritatively settled it. Paragraph, I'll just read this one small paragraph 57. I'll just read it, my lord, in that reported judgment, paragraph 57.
There are 57.
57 of the Anushka's judgment. Hence, the notification being sustainable prospectively, we hereby declare that the impugned portion of the notification, which provides for supersession of the notifications dated 11/4/2005, kindly note, even all these three earlier notifications have been now revived. So the supersession is set aside. Supersession of the notifications dated 11/4/2005, 5/1/2009, and 5/1/2009, and the clause 4(2), its proviso and explanation. All three. It is not just clause 4(2). the proviso as well as the explanation shall operate prospectively in respect of OCI cardholders who have secured the same subsequent to 4/3/2021. Kindly see the dates given by the learned additional Solicitor General. My OCI card was issued in the year 2012, 9 years prior to this date. So what the apex court has done is revived the earlier notifications. This superseding of this earlier 3 notification has been set aside or has been nullified literally as far as we are concerned. So they cannot by any stretch of imagination refer to the clause 4(2) or the proviso thereto or the explanation thereto to say that because of this notification, we are very much entitled to, we have the power to say that they are not entitled. Secondly, my lord, the learned additional Solicitor General has placed much reliance on the interpretation saying that belong to. I don't belong, according to them, I don't belong. Very well, my lord, for the sake of arguments, I as an individual, the petitioner before your lordship, though she has studied in that area, does not belong to the Hyderabad, Karnataka area. But what is it that the law provides? Law says it is enough for you to belong to that area if either of your parents were a domicile of that area. So can that provision of law be ignored? Belonging. My father was born there. He went through the same struggles that any person in that area went through. He studied there for 15 years. Though belonging to an OBC category, he got a seat. He passed out with flying colors. Opportunities were available. He went to UK. So what should be lauded or appreciated is that despite belonging to a backward area, my father came out with flying colors and succeeded in life. Further, what has to be applauded? He decides to come back. So that sense of belonging is there factually. It is a question of fact, whether I belong to that area or not. He decides to come back. It was very easy for him. From UK, I'll fly to US or I'll go to Australia. He says, I come back to India. Coming back to India, where does he come? Very easy for any Kannadiga to come to Bangalore, Mysore. Opportunities are plenty available, but he has this sense of belonging to his native place. He goes back there. He settles down there. He starts his practice there. And he says, you belong to this place, study here. Easy for him also. He has all the money. He can say, go to Bangalore, stay in a boarding or lodging, study in Mount Carmel, Maharani's or some such convent or Western education. No, stay here with me. You must also develop that sense of belonging. So on facts, he's absolutely right. It is meant for those who belong to that area. I certainly belong to that area is my respectful submission. Merely because I am born in the UK, you cannot uproot me. My roots are very much there. Therefore, my lord, I would say this belonging which is stated both in Article 371J and the interpretation that has been placed will not apply to me because I belong to that place. And the requirement of law, 317J is a broad principle. The requirement of law which has been approved by the state legislature is that it is enough if your parents are residents there, you belong to that area. That is how domicile is construed or interpreted by the presidential order itself. So on facts, they may say you were born there, you studied there for some time, your upbringing is different, your sense of belonging may not be there, but law recognizes that by virtue of your parents' domicile there, you are also belonging to that area. One benefit is given. Your parents, it is enough. So therefore, my lord, according to me, this and also learned additional solicitors submitted. Somebody, he just comes on a visit, studies yoga. 3 months, someone will come, 6 months, 1 year. They come here, study for yoga. They cannot be. But the rigor of law is much more. Not for a common or casual or tourist visitor. In the instant case, the person who comes to study yoga here, his parents may not even have visited India, a foreigner. Not even an ethnic Indian. Or if it is an ethnic Indian, both the parents are there, he or she has not even studied there, but after going there, she comes to know that Indian rich cultural history is there, tradition is there. I'll come back and learn yoga or dance or music. These can be accomplished, but 10 years stay cannot be accomplished. Now, if that person comes and stays here for 10 years, law makes no distinction. And he should have studied in his school. Not after coming, he is coming here for studying music at the age of 25. He should have studied from 1st standard till 10th standard, or his parents should have studied. If I satisfy that rigor, I don't become a casual visitor just to study or just to music or just to have a tourist sightseeing, come and have a look at here, 1 year, 2 years I spend and then go back. I'm not that kind of a visitor here. I have not, my father has not gone back, though he is still a UK citizen. He is here for the past 8-9 years. And the other aspect, I come and snatch away the seat. Everybody else, any OCA card holder to whom they are giving the benefit, tomorrow I'll fly away. Once I complete my medicine, the doors are open, I'll bolt like a horse, I'll bolt the stables and fly away to US. Same thing applies to every OCI card holder. Every OCI card holder to whom they have considered that they'll give a seat in general category will, after completion of his education in India, can fly away. He doesn't require a visa at all. An Indian citizen may require a visa. But if I'm a US citizen or UK citizen, I just catch the flight and land in UK. So this distinction that I am going to fly away once I complete my lord is applicable to everybody. I cannot be singled out to say that this is the factor. Nextly, my lord, again, this is with relevant to the applicability of the notification. No doubt the notification says for participation only. But that notification is not applicable. So not only participation in the written examination, but now they are saying participation in the counseling process and selected the seat according to my merit and rank. If it was mere participation in the examination, what is the point in my writing an examination if I am not eligible for admission? So it is not a question of mere participation, but again, participation, yes, that is what the notification provides. Kindly, my respective submission is notification cannot be looked into insofar as I am concerned. The last aspect, Mara, I'll conclude with that, and this is according to me very relevant. Learned counsels, Mr. Ramesh read out clause 4 in detail. He said clause 1 does not apply to me. On facts, clause 1 applies to me, but if the notification is seen, every way it uses or. So even if I don't fulfill one of those clauses, if I fulfill any one of those clauses, so it cannot be. Kindly see that domicile definition in clause 4. Clause A, if he is born in local area or either of his parents was born in that region, at the end, the date, cutoff date is given 1/1/2010, 13, clause 4.
You're referring to which?
The presidential order, Karnataka Educational Institutions.
4A.
Clause 4A. 4A. If he is born in local area or either of his parents was born in that region before 1/1/2010, 13, this is the cutoff date. So my father was born. I was born in India. I was a born citizen of India, but I was not born. I was born in Secunderabad. And at the end, or in the local area, or the word used is or. Even in clause B at the end of each one, clause B1 or, clause 2 or, then we come to clause 3. So it is enough if I fulfill any one of these conditions. They cannot insist they have to fulfill all these conditions because of the use of the word or. If it had been and, then they could have insisted that I have to fulfill each and every one of these conditions. The use of the word or clearly shows that it is enough if I fulfill any one of these conditions. I fulfill clause 3, even which they are not disputing. Now, the crux of the matter, and this according to me should settle the entire issue once and for all. Kindly turn to clause 6. This I had not pointed out during my opening arguments, but I'll just point out this one provision and rest my case. Clause 6. Admission to 70% of the available seats in every course of study in any regional university or educational institution referred to in the first schedule in the local area shall be reserved in favor of the local persons in respect of such university or education institution. 2. Clause 6(2). While determining under subparagraph 1. So while determining the 70% of the seats in any educational institution, the number of seats to be reserved in favor of local persons, any fraction of a seat shall be counted as 1. Kindly note the proviso. This gives the game away. What kind of seats are they and what kinds, whether it is reserved seat or not. Provided that there shall be at least one unreserved seat. This is the general seat. You can't have 100% reservation. You provide 70% reservation. Supposing there are only 2 seats. I am giving an example, my lord. It happens in post-graduation. MD surgery or MS surgery, MD general medicine at a higher level. There are only 2 seats available in each college. Now, if 70% of the seats in that college, 70%, it has to be rounded off. Then it becomes, my lord, 1.40. It has to be rounded off to the next higher digit, 2. Now, if both these seats are reserved, then where will the general category go? The proviso gives that. Provided that there shall be at least one unreserved seat. That means one seat is for reservation, sub-reservation, maybe scheduled caste, maybe scheduled tribe, OBC. One is a general seat. So this clearly stipulates that this Hyderabad, Karnataka is not a question of reservation. Though the term is used very loosely, it is more a question of providing a special point. Same with clause 7. Reservation in statewide universities and statewide so and so. While determining under subparagraph 1 the number of seats to be reserved in favor of the local persons, any fraction of a seat shall be counted as 1, provided that there shall be at least one unreserved seat. The use of the word reservation and then saying unreserved, it leads to an absurdity. So what the legislature itself had in mind while passing this presidential order, and when it was approved, that we give some representation to the region, we also provide for reservation, but there shall be general seats. Otherwise, it becomes violative of Article 14. So therefore, the attempt now to say that these are reserved seats, my lord, is not the correct proposition according to my respectful submission. These are the general seats in the Hyderabad, Karnataka area, which is clarified by clauses 6 and 7. Therefore, my lord, I am entitled to be considered for counseling for the Hyderabad, Karnataka general seats. Obliged.
Sir, comma, there is one thing which is not, may not be related to the controversy. Just to clear this 371J category, according to you, is a reservation.
Yes.
So then why there is a further reservation there? SC, ST, general category.
Within 371.
Within this quota. It is provided by the state government or in what way it
No, this 371J
sub-classification.
is only geographical. It is only geographical.
This is geographical.
Yes.
But
This will
so
be
it's a geographical reservation.
Yes.
So then there is further also general category. SC, ST, OBC.
Within that geography. One clarification to make. My learned friend referred to my submission on the expression belonging. So his submission was that this petitioner would belong to that region by virtue of
Parents.
by referring to that notification issued by the state. But my lord, my concluding submission would be that the notification would have to be understood as per the constitutional provision. And what clause 2 of 371J specifically says, for students who belongs to that region by birth or by domicile. It does not refer to their parents. It says for students. Lord, subclause A of clause 2 of 371J, an order made under subclause C of clause 1 may provide for reservation of a portion of seats in educational and vocational training institutions in the Hyderabad, Karnataka region for students who belong to that region by birth or by domicile. So it should, here the student is in focus. It should be that student who belongs to that region, either by birth or by domicile. So the notification issued by the state would have to be understood in the light of the fact that this refers to citizen, whoever it is. Even if it is the parents of the student, they also need to be citizens, is my submission.
That's all.
That is all. That is all. One, if I may clarify, there's one other aspect. The seats which they are giving under the general category to everybody else, that is governed by the Karnataka selection of candidates for admission to government seats in professional educational institutions, schools. This, I may just pass on the copies of that rule. Only one rule, Rule 5. Rule 5. I am just read out Rule 5, my lord, of that rules, my lord permits. This is the rule on which they are relying, but the rigor of this rule has been now relaxed. Rule 5, Karnataka selection of candidates for admission to government seats in professional educational institutions, Rules 2006. This is the rule referred to in the information brochure, in their notification everywhere. Rule 5, eligibility for government seats. My lord gets it, my lord. No candidate shall be eligible for admission to government seats unless he is a citizen of India and satisfies any one of the following conditions. Anyone. citizen. Now this rigor of citizenship goes. Now, if I'm in Bangalore and I'm seeking as an OCI card holder, the rigor of citizenship, then follows anyone. There, my lord, the last one at rule 6, just before rule 6, above rule 6, either of the parents should have studied in institutions run or recognized by the state government located in Karnataka for a minimum period of 7 years. So the same rule. But here the rigor is only 7 years. There the rigor is 10 years, which I satisfy. This is all that I wanted to point out. Obliging.
Third, learned advocate, Mr. So we are reserving it.
Please.
Third, learned advocate, so and so for the petitioner, learned. Additional Solicitor General, Mr. Arvind Kamath, assisted by you are for?
He is for the.
I'm for fourth respondent.
Assisted.
I'm for the fourth respondent union, Lord.
Union of India, fourth respondent.
My central government council is Swati.
Respondent number 4.
What is your name? Assisted by Madam.
Swati.
From a learned.
For 1 and 3 and NK Ramesh for R2.
At length. Then learned counsel for the party stated that they argued the petition. Finally, they further stated the pleadings are complete and no further are required to be added or supplemented, reserved for judgment.
Obliging.
It's interesting.
Very interesting.
For me at least, because I'm new to 371J.
It is the reservation angle which brought in the interesting element.
Thank you.
The list one, seal number 88.
And if it's an and either I. Right. Can I start? my lords may look at, my lord, one of the argument that was canvassed was, my lord, that notification itself, my lord, there is no acquisition in the eye of law. There is no pleading with regard to acquisition. No pleading, my lord, with regard to the invalidity. Please have a look at the writ petition for a minute. Page 50. 50. Sorry, 59, my lord, I'm sorry. The writ petition starts at 59. Actual petition, my lord, at 64 with the cost title. There is, my lord, what is not there, I can't show to your lordships. There is no plea with regard to the invalidity or illegality of the acquisition. This is one. Second contention is there is no final notification regarding acquisition. Sorry. My lords may look at, my lord, page 172, the preliminary notification, and 178, the other notification. One is a preliminary notification, the other is a final notification. I'll point out to your lordships. My lord, please come to, my lord, page 172. 172, my lord, is a preliminary notification. 174 is a final notification, my lord. If my lords look at the language of 178, it's abundantly clear, my lord, that it is a final notification. There is a declaration. Land is so-and-so, as amended by the land so-and-so, government of Mysore, His Highness the Maharaja of Mysore, declares that the lands mentioned in Soladevanhalli and Banavara villages, be the same, a little or more or less, are needed for the public purpose, to wit, Mysore Stoneware Pipe Potteries Limited. Page 178. That's the second notification. First notification, my lord, is a preliminary notification. Second is a final notification. And I'll point out, my lord, section 6 of the 1894 Act, if your lordship sees, my lord, there has to be a declaration. And that is, my lord, this
Declaration is at page 172.
178, my lord.
Where is that?
Please come to, my lord, 178, second line. Under section, it has to be, my lord, 6, my lord, that's a mistake. I'll point out. Under section 4 is what it says, typographical error. Land Acquisition Act, as amended by the Land Amendment Act, so and so, government of His Highness Maharaja of Mysore, declares, second line, my lord.
One
178. 172, my lord, is the preliminary notification.
Here declare word is not there.
No. Can I persuade your lordships? Just look at section 6 of the Land Acquisition Act.
That is correct, that intention and the final.
That's right. And then, my lord, my lord, in the morning, I was arguing a matter before my lords relating to, my lord, acquisition, that old acquisition. I'm just giving your lordships the notification there, final notification. Please have a look at it. Same language, same this thing.
Okay.
My lords my lord, next page, my lord, the typed copy I have put for my lord's consideration. In exercise of the powers conferred by Section 6 of the Mysore Land Acquisition Act 1864, the government of Mysore hereby declares that the properties mentioned below be the same.
So
a little-
both are of same date.
Same. Both can be of the same date also. My lord, I'll give you, lordship, my lord, two judgments for my lord's consideration. Honorable Supreme Court has held that, my lord, it is permissible to, my lord, court ಕೊಡೋದಿತ್ತಲ್ರಿ. My lord, can I persuade your lords to come to my lord page 30?
It's
Yellow misplaced.
it's okay. Just give the citation. Oh,
1960.
okay, sir.
ನಾನು ಇದನ್ನೇ ಕೊಡ್ತೀನಿ.
No, ಇದೆ. I've got it.
My lord, page 31.
Correct.
31 of the judgment list, my lord. This is, my lord, 1968. SCC online, SC 293. Please come to paragraph 3. On the next page, page 32. My lords may come to last 5 lines, my lord. Last 1, 2, 3, 4, 5 lines. Where section 5A does not stand in the way, the prior publication of a notification in the section 4.1 is not a condition precedent to the publication of a notification in the section 6.1. For this reason, this court held in Somavanti versus State of Punjab that where an order was passed under section 17.4 dispensing with the procedure under section 5A, it was lawful for the government to publish both notifications the same date. Then, my lord, is there a format? Answer is no, my lord. In fact, my lords may look at, my lord, the earlier judgment at page 23. Page 23, AR 1968, Supreme Court 615, paragraph 11, my lord, their lordships have held that there is no particular format for issue of a notification in the section 6 of the Land Acquisition. Lord, it starts at 23, at, my lord, 28 bottom. Para 11. The construction which we have put on section 6 is supported by the decision of Ezra versus Secretary of State. 1903 ILR 30 Calcutta 36 at page 81, where it was held that a notification under section 6 need not be in any particular form. The case went up to the Privy Council, but it appears from the report of that case that these observations were not challenged or disputed before the Privy Council. 1905, 32 Indian Appeals, 93. That's, my lord, the Privy Council judgment. We are also told by the Council that no statutory forms are prescribed by the West Bengal government for such a declaration, either under the Act or the rules made thereunder. Though there are model forms framed presumably for the guidance only of the officers of the Acquisition Department. There being thus no statutory forms, Section 6 is not required, Section 6 not requiring the declaration to be made in any particular form. Mere fact that the notification does not ex facie show government satisfaction, assuming that the words "it appears" used in the notification do not mean satisfaction, would not render the notification invalid or so on.
Yeah.
In fact, the declaration that possession is to be taken, everything is there, my lord, in section page 178, the final notification, similar to the one, my lord, which I pointed out to your lordship. Then, my lord, the submission is that the Tahsildar has passed an order. Deputy Commissioner, my lord, there's some, my lord, violation of principles of natural justice. My submission to your lordships is, it is immaterial, my lord, whether natural justice is, my lord, even if, my lord, assuming for the sake of argument that there is violation, only one conclusion is possible in the present case. There was acquisition upheld by this honorable court. He is a party, my lord, in another proceeding, my lord, where again, my lord, the acquisition was Land Acquisition Act, my lord, or Land Reforms Act, where the so-called tenant, my lord, claimed before this honorable court, and this honorable court specifically held that there is acquisition in favor of Mysore stoneware, and they are in possession. This, my lord, may I request your lords to just look at, my lord, page 45 of the compilation given to my lords. Page, my lord, in this, page 45, my lord, is 1976, 4 SCC 765. Please come to, my lord, para 25 at page 55. The engine background, the entire background of this, page 55, bottom, my lord. Para 25. Entire background of this case, we find a passage occurring at page 803 in the judgment of Lord Denning, Master of Rolls, in the case of Secretary R versus Secretary of State for ex parte Mughal, quite opposite to be quoted. The passage runs thus: rules of natural justice must not be stretched too far. Only too often, people who have done wrong seek to invoke the rules of natural justice so as to avoid consequence. Here, they suppress, my lord, the earlier fact that they were parties, all that. Anyway, next judgment makes it more clear, my lord. Please come to, my lord, page 81. 2006, 8 SCC 647. Page, my lord, 81. In this, my lord, paragraph 17, if my lords come to, my lord. At, my lord, 88. My lords, the paragraph 17 starts at, my lord, page 87. Please come to paragraph 88. Placitum A. The court will not insist on compliance of second line, my lord. Compliance of principles of natural justice in view of the binding nature of the award. Their application would be limited to a situation where factual position or legal position arising thereunder is disputed or not, where it is not in dispute or cannot be disputed. If only one conclusion is possible, writ would not issue only because there was violation of principles of natural justice. Here, my lord, acquisition upheld. He is a party in the other proceeding before this honorable court. That writ petition, my lord, appeal was filed, appeal also got dismissed. 84 years have lapsed. Lastly, my lord, subsequent purchaser cannot, my lord, challenge this. He is a 2009 purchaser. 3 judgments have kept for my lord's consideration. In the first 3 judgments, that's all. Grateful to your lordship.
Don't say that.
My lord, lastly, my lord.
You should not say that last judgment.
I'll tell your lordship. No, no.
Subsequent purchase.
Then, my lord.
Yes.
The last submission is, my learned friend said, my lord, that earlier notifications withdrawn. With the greatest respect, it is not so. What they have filed, my lord, we have filed on, my lord, 29th of July, 2024. My lord, this was filed before the learned single judge. It was not a part of the compilation that they have filed. On 29/7/2024. Please come to, my lord, turning page. Four, English translation at 5. Sorry.
29, sir. So what are you showing?
My lord, they produced one letter or, my lord, one document claiming to be, my lord, issued in their favor by the state archives, saying that this notification is withdrawn. Last time, my lord, my learned friend showed it to your lordships. We went back to the state archives.
Which
Said,
notification withdrawn?
the notification for acquisition.
Initially,
Acquisition.
38.
That is not so. Please come to, my lord, page 5, the English translation of that. We went back to the archives, asked them whether such a document exists. They say no. In the archives, it does not exist. Then more important is, we went before, my lord, the forensic laboratory. Forensic laboratory, my lord, states, comes to the conclusion, the signature of the so-called, my lord, chief secretary there and the chief secretary, my lord, admitted signature don't tally. One. Second, more important, the typewriter, my lord, the font is, my lord, of the year 1956. This document at page 928 is stated to be, my lord, of the year 1941. That report of, my lord, the forensic lab is placed before your, my lords, before the learned single judge. Please come to, my lord, running page 13, my lord. My lords, please come to 928. That's the document. At, my lord, page 13, this document compilation, my lord, 29. Forensic laboratory, my lord, report. Sorry, my lord, so many papers we have filed. You owe an apology. Page 13, my lord, 13, my lord, it starts from page 6. Please come to page 13, bottom. Conclusion. On a cumulative effect of all observations taken together, I am of the opinion that the characteristics of the disputed signature was not observed in the known signature. Hence, author of the known signature and disputed signatures are not the same. Disputed signature is highly probable to be poor result of a trace forgery. Then second, disputed document contains a font named Courier, which came into existence only after 1956. Hence, this document dated 1941 is fraudulent. Now, more important is, please have a look at that document, my lord, which they have produced. It's not the language of a chief secretary, my lord. Page 928, volume 4, if my lords take, that so-called, my lord, withdrawal. Please have a look at the language. My lord, it's not the language of, my lord, chief secretary. It's, my lord, some.
Page 14.
No, my lord. Page 928, that document, my lord, which they relied upon, my learned friend relied upon. Volume 4.
Volume 4. 928. Sir, 820.
Huh?
Use the page number as 820. 820.
825. My lord, it said, I am told, my lord, it is 825 because none in mine.
It's 820.
Look. 825. My lord, I am told 825. I don't know. All right.
Whatever.
All right. Sikta. My lord, please permit me to read, my lord. Government of His Highness Maharaja, that undermentioned land situated in Soladevanhalli and Chikkabanavara village, Bangalore North Taluk, Bangalore district private lands measuring 118, 24 guntas for all survey numbers. My lord, language of English language of Chief Secretary of those years. Government order dated so-and-so, February so-and-so, dated 15th of June to 1938, and number so-and-so, dated 24th of June 1938 for Mysore Stoneware Pipes and Potteries Limited. Government order, direct land, acquisition proceedings, failed. Reason, the intimate in-time procedure not following, but Deputy Commissioner, Assistant Commission companies, private landowners, payment records not available, final declaration not issued. This is can't be, my lord, this language of a Chief Secretary.
That is not the bank.
In fact, award also is, my lord, produced. The annexure R8, my lord, page 508, award is there, compensation paid, everything is there. Therefore, my lord, my submission to your lordship says, my lord, this at least grateful.
So this will be
May-
for
May I pray about 10 or 15 minutes for tomorrow morning?
then tomorrow, 15 minutes then tomorrow.
Oh, 15 minutes tomorrow. I request that notification. Volume put, so that I can answer. those points.
Indeed, it's my duty. Sorry.
That I will clarify. I just.
Lord, item number 43, my lords. Item number 43, my lords, sir. It is coming up. There's a batch of petitions, 20 petitions today, pertains to a government corporation, my lords, sir. There is an interim stay which I have sought for. So, item 43, my lords, notice has been served.
It is a delay application is there along with your.
Yeah, there is a delay application.
So we'll issue notice in delay.
No, they've already notice has been issued on item number 43. It has been served, but nobody has appeared.
Who appears? So what do you want?
I've deposited the amounts before the trial court, my lords. I just want to be protected, my lords, at least for some.
29th, we'll consider 29th August.
Serial number 40, serial number 40, my lord, there is urgency. My lord, the matter pertains to, my lord, the appointment. Lord, may have it, my lord, next week, my lord.
Serial number 47.
It's been coming.
September.
Serial number 47.
Serial number 35, my lord.
The complainant is not being paid salary for a period of 25 years. There is series of litigation is going on. So he has filed a contempt petition and the matter is not being reaching from past 3 years. So a date may be fixed, short date may be fixed.
September, 6th September.
My lord, serial number 36 and 38, my lords, environmental compensation. My lords vote here today. Board was notified that they should come today.
What is that?
That environmental compensation matters, my lords.
In that order which we are going to
28.
pass in
Yes.
those matters,
Yes.
review and other matters.
Yes.
Shall we record broad consensus or not?
No, my lords, these matters do not stand in the same footing, my lords. Here they declare.
No, the order or notice to be treated as so cause notice. And you are to be heard in respect of all aspects. That is the order we are going to pass in that order, which is already disposed of.
That's how the RPs were considered due to conceding of the board, my lords. In these two matters, my lords, this is a second round, my lords, where there is already order passed by this honorable court in 2020.
All right, what do you want?
That's one date, may kindly be earlier date, because they are going to implement and time and again officers are visiting, my lords. If stay is granted, my lords, then anyways,
Where is your opponent, Mr. Chowdhury?
they are not, they are not. Last date also they will. That's interim order, my lords, because they are going to consider that they want to treat.
30th August.
Serial number 35, my lord.
30th.